sometimes Mr. Robles is not in the courtroom every day, and although he is trying to have all of his drawings cleared by your representative, he's not been able to connect with her on all occasions, and perhaps that is how one of the drawings was broadcast without someone else in the court seeing it. It certainly was not done intentionally. But he has brought all of the drawings, so if you would could identify perhaps for him which one in particular was the one that you saw recently.
All right. Well, counsel, what I propose to do is enter a formal order to both your client and all sketch artists who are involved in this case that their drawings be submitted to the public information officer for approval by the court prior to broadcast. And the court, as you know, Ms. Hazlett is present here in the courthouse every day. And this court rarely leaves the courthouse before 6 in the evening every day. So we'll be available to, in an expeditious manner, review any drawings that you want to use immediately that day.
That would be fine, Your Honor. I think the problem has been there are deadlines, and Mr. Robles does not do his work here in the courthouse as the other sketchroom artists do. I believe they work up on the 12th floor. They perhaps have a little closer access to Ms. Hazlett, whereas Mr. Robles retires to the CBS trailer to complete his drawings, and I think that's how they've missed each other. But
well, if you want, what we can do is set up a regular schedule at the conclusion of business. We'll be available for, say, half an hour after the conclusion of business every day, or we can be available just before the start of the afternoon session for other deadlines.
I guess we'd have to have both in the instance that if there's a drawing that we need to use in advance of the evening news, it would need to be cleared before the close of session that particular day. If there is a drawing that we don't need to use, then yes, we could have it cleared at the end of the day. All
right, then I'll issue this order and I'll direct Ms. Hazlett to set up a regular schedule where she and the court will be available at the conclusion of each court session, both in the at the conclusion of the morning session, conclusion of the afternoon session. Is that acceptable?
That would be fine, Your Honor.
All right, then that'll be the order. All right, thank you, counsel.
Thank you.
Mr. Neufeld, people represented by Ms. Clark, Mr. Darden, and Mr. Goldberg. The jury is not present. All right, let's have the jurors, please.
Your Honor, we have a number of matters that need to be resolved before we take Mr. Matheson. I'm wondering if you want to do that now.
Yes, perhaps we should. Hold on to the jurors. Mr. Blaser.
There are several matters. There's the ruling on the serology chart.
All right, I received letter briefs from counsel on both sides with regard to that issue. Mr. Blaser, do you have any further comment you wish to make on that issue that is not included in your letter brief?
Well, the people just filed, or at least they handed me an unfiled copy of further paperwork on this just this morning. I don't know if the court's had a chance to review this or not.
I was handed something and told that it was going to be resubmitted.
No, and I said that we were not. There was only one type. There was one type of graphical error which I corrected in hand and then dated it. So
all right, Mrs. Robertson, would you grab that off my desk?
As I understand the argument in this new paperwork, the people are taking the position that there should be no testimony about the EAP-B results of the blood under Nicole Brown Simpson's fingernails, on the basis that they're now saying that unless they can testify about these other inconclusive results, this now becomes an inconclusive. And that argument makes no sense to me. First of all, I'm not sure how to respond to it because it's a senseless argument. There are a number of statements.
You mean to say it's a contradictory argument? Thank you. Never mind, go ahead.
Okay, both. I mean, there are other statements in this this brief that are just flat not true. They talk about how the typing results for the pool of blood under Nicole Brown Simpson shows a banding pattern consistent with a type B, and they say that this result was called an inconclusive B. I would like to have Mark, Mr. Matheson's report on this.
Yes. Yes. Thank you. Mr. Bladen.
If you will look at page 2 of this report, you'll see that item number 42, which is the blood under Nicole Brown Simpson, Mr. Matheson concluded that it was an inconclusive, not an inconclusive B, but an inconclusive. If you look also at the blood on Nicole Brown Simpson's thigh, which is item number 85A and B, in this brief they just filed, it's described as an inconclusive BA. In Mr. Matheson's report,
Number 85?
yes, in Mr. Matheson's report, it is an inconclusive. It is not an inconclusive BA. You'll also note that the fingernails, which are items 84A and B, are not inconclusive at all. They are a B, a straight B. And to represent otherwise is just simply not scientifically correct. Now, they may try to explain, well, it sure looks like a B, but maybe it was a BA at some point in time, and we're prepared to deal with that particular argument. But to change these other results to say, well, they were inconclusive before, but now we need to make them something else, is just simply scientifically fraudulent in our view and should not be permitted. So we would submit the matter with those comments on this brief that they just filed, as well as what I've already submitted in my brief before.
Mr. Goldberg?
Yeah, actually, Your Honor, it would be scientifically fraudulent not to admit them, and that's why we felt so strongly about this and have insisted on this to the extent that we have in filing a number of points and authorities and making a variety of arguments. We would like to call Mr. Matheson in a 402 hearing because we do believe that when the court understands these issues and it's not immediately apparent why the prosecution is taking the position that we are and why the defense is taking the position that they are. In fact, there's a certain aspect to it that's counterintuitive, because if you just look at the results on their face, the EAP result of the pool of the victim's blood being an inconclusive B is inconsistent with the defendant and is inconsistent with the victims in this case, and would seem to lend a theory that someone else deposited it. So you would think that the defense would be seeking to get that result in, that the prosecution would be seeking to exclude that result, because why would we want to put on a result, an inconclusive, albeit an inconclusive one, that's inconsistent with anyone in this case? Why would the defense want to exclude that result? It does seem to be counterintuitive, but when the court understands that scientifically, we know that the pool of the victim's blood has to be her blood, and therefore we know that the true type is a BA, and we know that that's not what we see when we test it. That tells us something about what is happening under the environmental conditions at the crime scene. And it tells us that type EAP BA blood is degrading in such a manner as to create the appearance of a B. And I think Mr. Matheson can communicate this to the court that I cannot, and that's why we would seek to put him on for the purposes of explaining this and perhaps using a chart that we have that we'd use with the jury to explain what this banding pattern looks like when it's not degraded, what it looks like when it is degraded, to explain the scientific literature that identifies this problem that we quoted in our most recent brief, and to discuss the literature that says that according to some analysts, you are required as a forensic scientist to look at the pool of blood and blood on the victim's clothing as a control study to determine whether or not you in fact have degradation on this one particular marker, because it has certain problems in terms of degradation that the other markers do not have. And we've cited the literature which says that Mr. Matheson is required, according to these authors, to do the precise thing that he is doing, and that he should not, if you accept these authors, express an opinion about the blood under her fingernails unless he's also looked at what's happening in the pool of blood and the blood that's on her clothing or on her person. Now, counsel has given you a copy of the analyzed evidence report, which simply reports inconclusives. It does not give an indication as to whether it's an inconclusive B or an inconclusive BA or what have you. On the electrophoresis worksheet, which in light of counsel's argument, I should probably also mark, only unfortunately my copy has writing on it. I'd like to give the court a clean copy. Do we have it? I'm going to get a clean copy to mark. But it talks about the EAP result on item 84A and B, which are the fingernail scrapings, and 85A and B, which are the dots of blood that came from Nicole Brown's thigh. And the way that it is called on the electrophoresis worksheet, which is the one that is done contemporaneously with the testing while you're actually looking at the plates, the analyzed evidence report is a formal document for external purposes, for attorneys and for the court and so on. But in what is actually a document that is generated at the time of the analysis, what Mr. Matheson says on 84A and B, that being the fingernails, is B question mark. And the question mark typically...
Mr. Goldberg, let's cut to the chase here. Let's assume that as a result of this challenge, the court needs to conduct a 402 hearing. What's your time estimate as to how long that'll take? And how do you suggest we accomplish this as expeditiously as possible, understanding we have a jury?
I understand that, Your Honor. And I don't like 402 hearings, and I don't believe that 402 hearings should almost ever be done with live testimony. So this is contrary to my ordinary practice, because I understand what the court is afraid of here, and that is that it's going to turn into a little bit of a mini trial on an issue where the prosecution feels that there is no factual or legal issue for the court to resolve. The bottom line conclusion that Mr. Matheson is going to give is that based on the totality of the evidence that he has in front of him, that the EAP results under the victim's fingernails are in fact
Well, Mr. Goldberg, I asked you two specific questions. How long is this going to take, and how do you suggest we do it?
Now, the way I would suggest it is this. Counsel has raised an objection to the people's chart. They haven't tried to limit the scope of Mr. Matheson's testimony or somehow force him into giving an opinion that is scientifically unsound or that is contrary to what he believes as a forensic scientist. So what I would suggest is this. If the court still has a problem with the chart itself for some reason, after looking at the people's brief, and the court believes that it would be helpful to hear more about this issue, then Mr. Matheson should simply be allowed in front of the jury to testify to this result, to other results, to how he's interpreted them, to the forensic science literature and what he believes the literature requires in making this kind of an interpretation, and his bottom line opinion. And after that, I think it will become clear to the court that the chart itself should come in as well as summarizing what is actually placed on the electrophoresis worksheet, because the electrophoresis worksheet does in fact provide that 85 is a BA question mark, or an inconclusive BA. And all of our results on the chart do in fact come either from the electrophoresis worksheet or from the analyzed evidence report. So it's a summary of business records.
Are you suggesting that I conduct this 402 hearing in the course of the presentation
Yes.
of Mr. Matheson?
Yes.
All right. I've heard that before. Mr. Glazier?
We certainly object to that. And let me make it clear, we're not objecting to Mr. Matheson testifying as to how a BA degrades and whether it can look like a B or not. We're fully prepared to cross-examine him on that issue. What we're objecting to is him testifying that inconclusive results are anything other than that. And the analyzed evidence report that he prepared was prepared after the worksheets and were based on their observations of the worksheets. This is the report he submitted for the attorneys and the court and for everyone else who wants to know about him. These are the results that he called. He called them inconclusive, and we object to him testifying anything other than that.
All right. Thank you. All right, the court finds that this particular issue as presented is an issue that goes to the weight of the testimony, the weight that is accorded to the testimony, not necessarily its admissibility. However, having said that, the court anticipates that we're going to see rather extensive cross-examination as to this particular issue. And I have to indicate to counsel for the prosecution that given Mr. Matheson's original report, I suspect I'm going to have to give rather wide range to the defense as to these, quote, inconclusive indicating a degraded sample. All right, let's have the jurors.
Yeah, there are other issues as well.
Such as?
The prosecution just brought in a new chart this morning on this very issue of the fingernails, and we have no objection to anything on the chart except there is a picture of Nicole Simpson's body from a long shot that I think it may have been used before in some other context, but it has no meaning really on this particular chart. We think it's overly gruesome and unnecessary.
Mr. Goldberg, will you get to that chart before we break for lunch?
I don't anticipate that I will, but it is possible.
All right, let's assume that we're not going to get to it. I'll take a look at it over the lunch hour.
But I believe
I'd like to get rolling with the jury this
I
morning.
believe it is a photo that's been introduced. And then counsel also had another motion that
Has
they
to
filed
have some
this morning.
relevance, though. But
What?
I'll look at it over the lunch hour.
Yeah, we did have an additional motion that Mr. Neufeld is prepared to argue that we filed this morning concerning the order of proof. In essence, we're objecting to Mr. Matheson testifying to any test results on Mr. Simpson's blood before they call, without proper foundation of the person who drew the blood. And Mr. Neufeld's prepared to.
Well, I assume I'll hear that objection as soon as there's some testimony regarding the blood, that foundational objection.
And finally, there was a brief filed on Thursday, I believe, about the business records exception and
Regarding chain of custody.
regarding chain of custody. We have no objection to testimony from Mr. Matheson about what amounts to ministerial acts of putting things in packages and sending them off to other labs. But we would object if they have any intention of offering testimony about Mr. Matheson testifying about tests that some other person did or evidence collection that some other person did under that exception. But I understand from Mr. Goldberg they don't intend to do that, so that may be a moot point.
I don't have a present intention of doing that, Your Honor.
Terrific. Glad to hear it. Let's have the jurors.
And finally, we would object in advance to avoid a sidebar if possible, that if they intend to ask Mr. Matheson any questions about anything that our experts have done, either at some other location or in Los Angeles, we object to that and want to be heard about that before that's done.
All right, that would seem appropriate. Mr. Goldberg?
I do have a present intention of doing that, Your Honor.
This morning's session?
I don't think we're going to get to it this morning.
Okay, give me a heads up when that comes so we can discuss that out of the presence. Let's have the jurors, please. Rejoined by all the remaining members of our jury panel. Previously in chambers, the court conferred with counsel. The court has found good cause to excuse from further service juror number 2. Mrs. Robertson, would you please draw a number of an alternate juror to take seat number 2?
Juror number 1427, can you please have a seat in seat number 2?
All right, Mrs. Robertson, at the noon break, you'll renumber the seats and provide court and counsel with a revised juror chart.
Yes,
All right, Mr. Goldberg, would you call the people's next witness?
Yes, people call Gregory Matheson to the stand.
raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness stand and state so your first and last name for the record.
Gregory Matheson, Gregory Matheson.
Mr. Goldberg.
Sir, what is your occupation and your current assignment?
I'm employed by the City of Los Angeles, working for the Los Angeles Police Department Crime Laboratory. I am currently what is called a Chief Forensic Chemist 1, which is Assistant Director of the laboratory.
Okay. And, sir, in that capacity or in any other, are you part of any conspiracy in this case to frame the defendant?
No, I am not.
Or a part of any cover-up and for the purposes of framing the defendant?
No, I am not.
Right. Now, you said you're the chief forensic chemist,
Yes, that's the title.
and why is it called that?
Well, that's a civil service class that was assigned to that position a while back. It exists in two-step. The Chief Forensic Chemist 1, which is an assistant director position, and the Chief Forensic Chemist 2, which is a laboratory director.
All right. And how many chief forensic chemists are there in the crime laboratory?
Well, there's a total of 3, 1 director and 2 assistants.
Okay, I'm going to get into your training and experience in a few moments, but did you perform some of the conventional serological testing on some of the biological evidence in this case?
Yes, I did.
Right. And also, did you participate in managing the sending of items out for analysis to outside laboratories?
Yes, I did.
All right. Now, do you have a degree that qualified you to become a criminalist at the Los Angeles Police Department?
Yes.
And what was your degree in?
Well, I have a degree in criminalistics from California State University at Long Beach.
When did you get that, sir?
Was in May of 1977.
And I want to ask you about some of the other courses that you took since then. Do you have your curricula vitae in front of you? Do you need to refer to that to give us specific dates and times?
Yes, I do.
Okay.
All right, very reflective. Mr. Matheson does have before him a ring binder with a number of pages in it.
Sir, since you graduated in 1977, have you taken a fairly large number of courses in furtherance of your training and experience as a criminalist?
At that point, it depends on what you mean by courses. I have had a handful of what I'd call formal training or courses, along with attendance at a number of seminars and meetings and that type of thing.
Okay, I just want to go through some of the courses and seminars that are pertinent to the issue of serology. And let's start with the 1982 two-week FBI class. What was that about?
Well, in 1982, I took a 2-week course called Biochemical Methods of Blood Stain Analysis that was offered at the FBI Academy in Quantico, Virginia. That was mainly about the electrophoretic determination of genetic marker types. It's the steps or the process that's used in what has been called conventional serology to identify the types of enzymes that are present in the body.
Okay, and just so that we're defining some of these terms, when you say conventional serology, that is distinguished from what?
That term came around as DNA analysis in forensics started becoming possible or used within the field. In a way to define the difference, we started calling the systems and techniques that we'd used for many years as conventional, and the rest as being DNA.
And when you say electrophoretic techniques, we'll get into this in some more detail further down the line, but can you just give us a simple definition?
Well, electrophoresis is a process or a technique whereby a gel is poured, samples of biological materials placed on one end of it, electrical current is passed through it, and the end product is a sequence of bands that can be interpreted to tell you what type of blood you're looking at.
And were these techniques, the electrophoretic techniques and ABO type testing, around for a significant period prior to the use of DNA technology?
Yes, they were.
Now, in 1987, did you attend the serology symposium dealing with the collection and preservation of evidence?
There was a symposium held at that year which involved attendance by a large number of forensic scientists, mainly in the California area, I did attend it. However, I was also one of the working groups or met with one of the committees for several months prior to that in preparation of the meeting. The area that I was involved in was standards of training.
Okay, and what was the focus of this particular symposium?
The focus of that symposium, which was to elicit what was the standard practice or the consensus of practice within the forensic community at that point in time.
In terms of what?
What we were calling conventional serology.
Did this deal with any of the collection and preservation aspects or just the testing aspects?
No, it also involved collection and preservation.
And was there any product that was generated as a result of the symposium, such as a manual or a pamphlet or publication?
There was a kind of a loose covered document that, I don't know the number of pages, it's about a 1/4 inch thick.
All right. And did that cover the subjects of the collection preservation and also the conventional testing?
That's correct.
All right. Now, was a lot of focus placed at this serology symposium into the mechanics of how you actually collect a stain from a crime scene?
The actually getting down on your knees and
Right.
No, it didn't go into that aspect of it very much at all.
And do you know why?
The only reason that I
Sustain.
Well, you were part of this working group.
No, the working group I was in dealt with training.
Okay. Has the actual mechanics of how you collect a stain been a controversial issue or a widely discussed issue in the forensic field?
No, it is not,
Why not?
because it's a fairly basic process. Even in reviewing a number of forensic texts, there's very little reference to that step. They talk about locating the stains and eventually then, packaging and preserving them, but the actual collection is not addressed very often.
Now, going back to some of the courses that you took, in 1989, did you take I guess 2 classes at the University of New Haven, Connecticut?
Yes, they were held at the university. However, they were, it wasn't like a university course, but it was held at that facility.
And can you tell us what the 2 classes were?
Well, one of them dealt with the ABO typing of bone samples, and the other was an overview of DNA.
When you say ABO typing, you're referring to what?
Well, that is, it's a fairly common, what we call genetic marker. Matter of fact, it's the genetic marker that most people are aware of. You are either a type A, type B, type O, or type AB, and that's a system that hospitals usually use when they're cross-matching blood for transfusions.
Is that also used in blood banking?
Yes, it's what's commonly referred to as your blood type.
Okay. How long has that system been around?
I believe it was originally identified at the turn of the century, 1900.
So one of these courses dealt with, was it just ABO typing of bones, or did it also deal with electrophoresis?
No, that was strictly ABO.
Okay. And and you said the other course had to do with DNA
Yes.
techniques? And what type of DNA techniques did that deal with?
I believe it was mainly about RFLP, but we also spoke a little bit about the PCR technique.
And those are 2 of the techniques that are used in DNA typing.
Yes.
And was this course instructed by a leading advocate of using DNA technology in forensic cases?
Sustain.
Okay. Was the person that taught this course in favor of using DNA technology in forensic setting?
Well, actually, it was taught by several different people. They brought in several different speakers to talk on the different subjects. But yes, most of the people that were there because they believe in the technology.
And was there any particular individual that's prominent in the forensic field that taught this course?
One of the people that was involved in both setting the course up and presenting it was Dr. Henry Lee, which is the head of the Connecticut State Crime Laboratory.
Okay, and does he advocate using or support using DNA technology in forensic cases?
Sustained.
Okay, well, did he actually teach some of the courses that you, or one of the courses that you attended?
I believe he was involved in presenting some of the information.
All right. Did he appear to be a supporter of using DNA technology?
Yes, he did.
Now, in January of 1990, did you take a 2-week course relating to DNA technology in forensic cases?
Yes, I did.
And where was that course held?
That course was held in Denver, Colorado, at the Analytical Genetic Testing Center.
What did the course, how long of a period of time did the course last?
It covered 2 weeks. The first week dealt with this technique I mentioned before, RFLP typing in general, the basic background to it, involved in actually performing some of the tests. The second week focused a little bit more on the technique that was used by the FBI.
Okay. And then in June of 1990, did you attend some training at the University of New Haven and Cetus Corporation?
Yeah, this point is being relevant beyond his expertise.
Yes, I did.
What was that training?
That was a course that was offered by the Cetus Corporation, which I believe at the time was the manufacturer of the PCR kits that were being used for forensics. And it involved the theory and practice and techniques in PCR analysis, along with some hands-on getting a chance to run the techniques ourselves.
Okay. How long was that course?
I believe it was 5 days.
Now, in addition to these courses that we just mentioned, did you attend seminars of the California Association of Criminalists?
Yes, I have.
And when did you start attending those seminars?
Well, I became a member of the California Association of Criminalists in 1979 and attended every seminar I could go to. From that time till now, I believe they're held twice a year, and I think I've only missed 3 or 4 over that time period.
How long are those seminars?
Normally they last 2.5 days, a full day Thursday and Friday and half day on Saturday.
What range of topics do they cover?
Just about anything to do with forensic sciences.
Did they deal with serology issues in these seminars?
Many times serology is one of the main topics of discussion, both in the papers that are given and outside of them.
And by the way, what is serology?
Serology deals with the analysis of body fluids.
Okay. Now, and you said that these seminars by the California Association of Criminalists are twice yearly?
That's correct. Once in the fall and once in the spring.
And as a result of attending these seminars, do you learn the practices that are standard within the criminalistics profession?
That's part of it. Like I said, the seminars have a wide range of topics, from techniques that may be used in the future that are just becoming available to us, to hints and tips on how to do, current techniques better, and just, generally kind of dealing with this, the topic in general.
Are the forensic scientists who attend these seminars coming only from California, or do they come from other places as well?
No, they can come from just about anywhere. As a matter of fact, our last meeting, which was held in the fall, was done in conjunction with the Forensic Science Society from England, and we had a number of attendees join us from England.
Okay. Now, is there also an organization known as the American Academy of Forensic Sciences?
Yes.
And are you a member of that organization?
Yes, I am.
Do you attend their seminars?
I have attended about 4 of them, yes.
And how long are their seminars for?
Well, they tend to, the actual papers or technical presentations are basically the same as the CAC meetings, or the California Association of Criminalists, in that they're about 2.5 days. The meeting itself can run anywhere from 6 to 8 days, because there's an awful lot of, ancillary type of activities that go on.
And is that, are those seminars along the same line as the California Association of Criminalists, or do they differ?
Well, in that they cover a lot of different areas of forensics, they're the same. They are significantly larger, though, because that's a national organization, and it's composed of not just criminalists, but forensic pathologists and odontologists, dentists, and a lot of different areas in forensics. And each of these specialties are meeting, at the same time in different areas of the same facility.
So when you attend one of these meetings, do you go to all of the presentations, or just the ones that are involved in your area specialty?
Well, you can't go to all of them because a lot of them are running at the same time. I try and not just stay with what I've spent most of my time with, and that's serology. I like to, attend all those that seem interesting or appropriate, but also get out and get some exposure to some of the other areas.
And as a result of attending these meetings, do you also get an idea of the standards and practices that are being used in the forensic community on a nationwide basis?
Yes.
All right. Now, you mentioned this manual that was generated from the serology symposium, but other than that, have you had the opportunity, or have you had time to publish papers yourself while you've been working at the Los Angeles Police Department?
I have never personally published any sort of scientific paper.
And why is that?
Well, normally, an awful lot of the papers that appear in scientific journals and that type of thing deal with research, validating existing systems, bringing new systems online, that type of thing. My interest has not been in research. I enjoy applying the technology. I've always enjoyed doing casework. And a mere fact of the fact that we're with the Los Angeles Police Department and our criminalistics laboratory has a very high caseload. There's unfortunately a lot of crime in the city, and it does keep us busy just doing casework. So it's a combination of the two things. I don't have a strong interest to get out there and publish and do that, and I enjoy doing casework, and there's plenty of casework for us to do.
When you say casework, you're referring to what?
Anything that comes into the laboratory associated with a crime or incident within the city of Los Angeles could range from the type of casework the laboratory gets, runs the gamut from narcotics to serology cases associated with homicides and rapes to blood alcohol analysis, just about anything.
Okay, let's turn a little bit to your professional career. When you were in school getting your degree in criminalistics, did you work for any law enforcement agencies?
Yes, I did.
What agency did you work for?
For the Culver City Police Department.
And in what capacity did you work for the Culver City Police Department?
My title was a community service aide, and then it got changed to community service officer. Basically, it was a student position. It was part-time during school and then full-time during vacations and holidays. I worked a couple of different assignments. I was with them for about 5.5 years. Initially, I was assigned to patrol, where I'd go out and, assist with booking prisoners when they came in, take burglary reports, just simple things. Occasionally, have to write parking tickets, that type of thing. I eventually, actually, as soon as I could, got transferred out of that area into our identification unit because that interested me more. And in that unit, I learned how to process a crime scene. I'd fingerprint burglary scenes, photograph scenes, go out and fingerprint and photograph whatever type of crime scene that happened to come up.
Now, you said identification unit. What's that?
Well, normally, crime laboratories tend to exist only in the larger cities, counties, state, federal government, that type of thing. Small municipalities, as a rule, do not have crime labs. They have what are called ident sections or identification sections. They focus in on evidence collection, fingerprinting, and photography.
When you were working with the identification section at the Culver City Police Department, were the people that you were working with criminalists, or did they have some other job classification?
Well, we're talking about a small department. The person that I worked directly with would be another civilian. It happened that the two people that I worked for, they were identification technicians. They were both retired, one from the Los Angeles Police Department as a fingerprint person, and the other was retired from the LA County Sheriff's as a fingerprint person.
But did they also do things like collect biological evidence, or was it limited to fingerprints and the like?
No, if there was a reason, if there was a crime that involved biological stain or evidence, either they or I would, depending on who handled the particular scene.
So they were collecting biological evidence even though they were not criminalists?
That's correct.
Okay. Is that standard throughout the state in terms of the way law enforcement agencies, or many law enforcement agencies, collect biological evidence?
Sustained.
Well, sir, are you aware of the standards and practices in a variety of law enforcement agencies as a result of your participation in these various state and national organizations you've testified to?
Oral.
I am aware that the personnel that are used to perform different tasks varies from agency to agency.
And do some agencies use criminalists, whereas others use technicians, identification technicians?
Yes, that's correct. I mean, in the case of City of Los Angeles, we have criminalists. We do not have ID techs or identification technicians, so we use criminalists to collect that. Like I mentioned, many smaller municipalities that don't have crime labs have their ID techs collect the evidence, and actually there are some cities that have their own crime lab that also hire ID techs that are the ones that go out and process, mainly the simple scenes, but process scenes.
Okay. Now, when did you first join the Los Angeles Police Department as a criminalist?
It was in June of 1978.
And by the way, are you a sworn personnel as a criminalist?
No, I am not. Our criminalists are civilian.
Okay. Now, when you first joined the Los Angeles Police Department in 1978, what was your first assignment?
Well, I was hired in as a criminalist 1, and I was assigned to the toxicology unit.
And how long were you at the toxicology unit?
I worked toxicology from June of 1978 until I believe it was early January of 1980, so approximately 18 months.
What was your next assignment after you were finished in toxicology?
Okay, after working toxicology, I was transferred to what we call a special testing unit, and in that unit, I dealt with maintaining a couple of analytical instruments, running some of the more unique or unidentified drugs or narcotics, bomb debris analysis, poisons analysis, a variety of different things.
So what does special testing do in terms of, I mean, do they just test anything and everything that's unknown, or what?
Well, with the way our laboratory is laid out, the special testing unit has some specific assignments, such as any sort of bomb residue case, a poison case, that type of thing, go directly to that unit. Beyond that, basically the people that work that unit get whatever doesn't fit into any of the other units. It's things that handle some sort of unique or special handling.
Okay. And you were there for 18 months, you said?
Actually, it was a little longer. I believe it was from January of 1980 until I think it was August of 81. So it'd be about 20 months.
All right. And where did you go after you were finished with your assignment in special testing?
After that, I was assigned to serology.
And how long were you assigned to the serology unit?
Well, as a criminalist 2 or doing bench work, would have been until I believe it was May of 1988 when I was promoted to what was called a Crim 3 then, which was our supervisor position.
Were you a supervisor in serology initially?
Yes, I was.
Okay. Now, you used another term. You said bench work. Is that the same as casework or different?
Yeah, that's a term that's used for the person that's actually sitting working on the evidence, doing the analysis, is called bench work.
Okay. How long have you been a supervisor at the Los Angeles Police Department and the crime laboratory? How many years?
Actually, I probably should have referred to my notes before. It was May of 89 when I was promoted. So it'd be from May of 89 until October of 94 that I was a supervisor.
So when you were first a supervisor, were you supervising anything other than serology at first?
Well, my unit was serology. I was also a member of one of our special field response teams that goes by the name of the Forensic Accident Investigation Team. That was formed while I was a Crim 2. Myself and two other criminals were assigned to this. It was a special assignment to go out and collect evidence from specialized crime scenes, mainly those that were vehicular-related homicides, hit and runs, that type of thing. When I became a supervisor in May of '89, I was supervisor then of serology plus of this team that I was on.
And when you initially became a supervisor and you were supervising this team in serology, did you still play an active role in the bench work that was going on in the unit?
Yes, I did.
Right. And in addition to that, did you also have any function in terms of reviewing reports and confirming results and the like?
Yes, as supervisor of the unit, one of your goals is to, or jobs, is to review the analytical notes that come out of the criminalists or the analysts that are working the units before a report can be submitted out. We want to have it reviewed by a supervisor and either signed as being complete and accurate or returned to the analyst for either correction or updating, whatever required.
Were you performing any function in terms of actually reading other people's electrophoresis plates or photographs of the plates?
Well, actually, for the first, 3+ years of being supervisor of the unit, I was still doing casework. Obviously, it wasn't at the same level as I was before, but I was still a analyst within the laboratory. In addition to that, these electrophoresis plates that I previously described with the bands on it, they were always co-read, either by the original person that did the run, plus then somebody else that was following up on it. Didn't have to be a supervisor, it could be a co-worker. I continue, as a matter of fact, to this date, still continue to occasionally co-read plates.
Okay. Now, approximately 6 months ago, did your position within the crime laboratory change?
Yes, it did.
And what did it change to?
Well, in October of 1994, I was promoted to my current position of Chief Forensic Chemist 1, and I currently manage what's called the Forensic Analysis section of the crime laboratory, which includes not only serology, but other units such as our trace analysis unit, chemical processing unit, which does fingerprints in-house, our firearms unit, a Valley unit, and question documents.
And are you still performing bench work in this capacity, generally speaking?
No, I'm not.
All right. Are you still performing work in terms of looking at other people's electrophoresis plates and co-reading them?
Occasionally. It is not near as often as it used to be, obviously, but if somebody has some work that's been completed and they want it reviewed and there isn't anybody else available in the unit for whatever reason, then they have come and asked if I'd go back and do a co-reading on it.
Are there any plates that only you are qualified to read or that you have to read in the laboratory?
There is one system that called haptoglobin that I tend to co-read more than anybody else. I don't know if anybody else at
How do you
this
spell haptoglobin?
HAPTOGLOBIN, I think.
And why is it that you tend to co-read that more than others?
Well, everybody has their own interests when it comes to a particular system or something within the unit. One of the criminals that works the unit now is the one who runs them the most, and she and I have worked together with it on the past. So I tend to read them for her when she has one of these come available. I haven't done it in, I think it's probably been a month or month and a half, so either she's not running that system as often or somebody else now in the unit is trained in co-reading.
Okay. Now, with respect to some of the professional organizations that we asked about, is there also an organization called the American Board of Criminalists?
It's the American Board of Criminalistics, yes.
Criminalistics. And what is that organization?
That is an organization whose function, actually sole function, is the certification of criminalists on a national basis.
And did you play any active role in that organization?
Yes, I did.
What was that?
I was involved in forming it. I believe it was in 1987 or 88. A group of people was called together And I was one of those who was invited to attend as a guest because I had some experience in a certification program, a meeting held back in Chicago. And out of that meeting, I eventually was born the American Board of Criminalistics, a incorporated nonprofit organization. And I said I was part of that original planning group of it. And then for the first 2 years of its existence, which I believe was from February of 90 through 92, I sat as the vice president of that organization.
And when you say that this was involved in certifying criminalists, what does that involve?
Well, the process of certifying somebody is that you want to know or have some sort of indication that they possess the basic skills, minimum skills and knowledge to be able to perform their job. And in criminalistics, there was a lacking of a system like this, particularly on a national basis. So what we did is, in establishing this organization, gave the professional criminalists throughout the country a body with which they could apply to, take a test, do proficiency testing, these type of things, to be able to demonstrate that they have the minimum criteria necessary to do this type of work.
And what type of showing does a person have to make, or a criminalist have to make, in order to get the certification?
Well, there's actually a couple different levels of the certification process. To be in the American Board of Criminalistics, to be what's called a diplomate, you have to have, I believe it's 2 years experience in forensic sciences. You have to pass a written examination that is on general criminalistics, not in any one particular field, and be working in the field, actively working in it.
And do you have that?
Yes, I do.
Now, is there also an organization known as the California Association? Well, we talked about the California Association of Criminalists, and you said you joined in 1979.
Yes.
Did you hold any sort of positions within that organization other than just being a member?
Yes, I have.
And in 1987, did you begin to hold an office in that organization?
Well, in 1987, I was made the chair of the certification committee. At that time, the California Association of Criminalists was interested in starting the certification program, actually before the national effort began. And the first step towards doing that is putting together a committee. I was the first chair of that committee when it was formed. I believe it was either in January or February of 1987, and held that position until the program was actually up and running and we were testing people and offering certificates.
Right. And did your status in that organization change in approximately May of 1990?
Yes. In May of 1990, I was appointed to the position, a board of directors position called the Regional Directors South. Our association is basically divided in North and South. And I sat on that position on the board of directors for 1 year.
And then in May of 1991, did you run for president of that organization?
Yes, I did. Actually, you run for president-elect. It's a 3-year commitment. The first year you're president-elect, you sit on the board. It's a board position, kind of learn the job. The second year is as president of the association. The third year then is the immediate past president, where you still stay on the board, have an active position in it, but it gives you a chance to wind down and assist the current president.
And did you serve in that capacity for those 3 years?
Yes, I did.
So then your term ended in May of 94?
That's correct.
Do you continue to serve on any committees or any organizations within the California Association of Criminalists today?
Yeah, at the moment, I currently belong to 2 committees. One of them is a publication committee that is involved with putting together our newsletter, and the other is a financial review committee. I would have liked to have been more active on it, but I've been a little busy lately. So though I belong to them, I haven't been as active as I'd like to be.
And are you also a member of the California Association of Crime Lab Directors?
Yes, I am.
What's that?
That's an association that I don't know what our current membership is. I think it's probably in the 80 to 90 range, that's made up of managers and supervisors of crime laboratories, mainly in California, but we also have members from other states.
And While you were working in the serology section of the Los Angeles Police Department, can you give us an estimation of approximately how many ABO tests you performed during that period of time?
I'd like to, I didn't memorize those numbers. I did make myself up a kind of review chart of the type of tests and the quantities that I did. Okay, during the course of my career in serology.
Hold on just a second. Let counsel review the chart that you're referring to. All right. Thank you, counsel. Proceed.
Okay, in the area of ABO typing, I estimated that I've done approximately 6,500 of those type of tests.
Okay. And approximately how many electrophoresis tests have you performed on something called PGM subtype?
That would be, it was approximately 1,000.
Okay. Now, I'd like to ask you a little bit about crime scenes. Have you had any experience in actually going out to crime scenes during your professional career at the Los Angeles Police Department in processing crime scenes yourself?
Yes, I have.
And approximately how many crime scenes would you say that you've processed?
My best guess is about 150. I didn't have real good statistics on that, but that was my best estimate. I think it's conservative.
Have you ever rigged up any mock crime scenes for training purposes?
A couple, yes.
And when you attend these seminars at the California Association of Criminalists and the American Academy of Forensic Sciences, do they cover crime scene investigation as some of the topics in those seminars?
Sometimes they do, yes.
Have you trained any people within the Los Angeles Police Department in terms of crime scene investigation?
Yes, I have.
Have you trained any people outside of the SID section in crime scene investigation techniques?
Yes.
Who would that be?
Well, I have been one of the instructors in a couple of our detective training courses that we offer. One of them is the sexual assault detective school. They obviously focus more in scenes and evidence collection related to sexual assault. I also have taught for a couple of years at our homicide detective school, teaching them on the division's capabilities, SID's capabilities when it came to crime scene and simple evidence collection techniques. I also teach at a detective supervisor school, and we touch lightly on field techniques.
When you say evidence collection techniques, have you ever taught detectives how to collect a stain using LAPD's procedures?
Talking about a biological stain? Yes, I have.
And why are detectives taught that?
Well, we want the detectives to be able to have the capability of collecting biological stains, blood drops, that type of thing, if a criminalist isn't available. Though we do have an on-call system where a criminalist is available to be called out any time of the day or night to assist with evidence collection, we're not always called. Sometimes the scene may only have one or two drops or one or two items. They don't feel it's necessary to call us, but that's still evidence that we want to have captured for later analysis. So we have been for, I believe it's the last at least 6 or 8 years, training homicide detectives mainly on the proper techniques for collecting biological evidence. We supply them with a blood collection kit, which is simply a file box with the tools that are necessary in it to collect those samples.
And are they taught how to, take a control and use the distilled water and use the tweezers and the whole 9 yards?
Yes, they're both shown in a demonstration form. We talk to them about it. It's demonstrated to them, and if time permits, we have them practice it within the class.
And are detectives, in fact, collecting biological evidence in the Los Angeles Police Department and submitting it to your laboratory for analysis?
Yes, they do.
Okay. Now, does the Scientific Investigations Division also have a field unit?
Yes, we do.
And who supervises that now?
Well, right now, the unit is They have a lead criminalist, or what we call a criminalist 3, that's in charge of that unit. That person also works in another unit. Our trace supervisor is the immediate supervisor of them, and then I manage it.
Now, why wasn't the field unit assigned to processing the evidence or collecting the evidence in this case?
The deciding who ends up processing a scene is mainly a function of what time the call comes in. Like I mentioned a few minutes ago, we have people that are on call, criminals that are on call 24 hours a day, 7 days a week. However, if a call comes in during working hours, normal working hours, which for our field unit is 7:30 to 4, Monday through Friday, rather than send the off-watch person who may have been up the night before or may be going out the following night, we send somebody from this field unit to do the evidence collection.
Is the field unit, are the people assigned to the field unit necessarily more experienced in crime scene processing than the individuals that are criminalists who are on rotation?
No, not necessarily. They can be. Our field unit consists only of Crim 2 individuals, or those people that have advanced to the point where they could handle a crime scene by themselves if they had to. However, we rotate people through that unit just like we rotate people through our off-watch on-call situation.
So if, in this case, the evidence shows that there was a Bronco search that occurred on the 14th during the daylight hours, why would the field unit not respond to that as opposed to Mr. Fung and Andrea Mazzola?
Well, what we try and do is maintain some consistency throughout a particular case. If it's possible, the person that handled a scene, say the night before or week before, if some sort of follow-up occurrence occurs, like a car search or an additional scene, we want the same people handling it that handled the original scene. So in that case, that's why we did not send out somebody from the field unit.
Would you always have to, if you had two criminalists that responded to the first scene on day number 1, will you always send the same two criminalists to the second scene, or can just one or the other go?
Now, we can, it depends on the circumstances. We can just send one of the team, or if neither one of them is available, we will go and send somebody from another part of the laboratory.
But is there any rule that if you use 2 on day 1, you have to use the same 2 on day 2?
No.
Right. And typically within the Los Angeles Police Department crime laboratory, do you always send 2 criminalists to investigate a crime scene?
We try and get 2 people out to a scene whenever possible, yes.
Are there instances where only 1 is sent?
Well, we make an evaluation as to the complexity of the scene. If it appears that it's going to be something very simple, maybe a simple car search or something involves going to a tow yard and doing an examination, there are times where we will send only 1, but we believe 2 people can do a better job.
And was there ever any management decision that was made not to send Andrea Mazzola out to certain subsequent scenes after the 14th?
Oral.
As far as, I mean, there obviously are decisions made when somebody is sent or not sent. So in that case, it was. There has never been a decision made that said she will not handle any more scenes. No.
Well, that's what I meant. There was never a decision like that.
That's correct.
So if on a subsequent scene you only, because of the complexity, needed 1 person, you would send 1 person out?
That's possible, yes.
Now, in this particular case, before testifying, have you watched some of the proceedings or heard some of the proceedings on television or on the radio?
Yes, I have.
And have you heard some of the testimony and seen some of the testimony relating to the crime scene processing?
Yes, I have.
And did you also speak to me about the testimony that you were going to give?
Yes.
What were the nature of those discussions?
Mainly, it was a two-way thing. I was in preparing you for what I was going to be testifying to, just as you would talk and tell me some of the areas that we were going to discuss. Normally, it is just acquainting each of us with styles and with general topic areas that are going to be brought up during direct examination.
Did you also provide me with some instruction in terms of how ABO typing and electrophoresis is performed and certain technical topics such as that?
Yes, that was part of my comment about preparing you for it. There has been kind of a training process going on to acquaint or to acquaint you with the techniques and the procedures that we use.
Have you also talked to any defense lawyers and provided them information about the case as we progressed?
Yes, I have.
And is there any rule within the LAPD crime laboratory with respect to talking to defense lawyers? I mean, how does that work?
The only rule that we have deals with discovery materials, and that is that if items are going to be released to the defense, that the prosecutor's office is aware of it, and that if it isn't your own work, that the original criminalist is aware that these informations are being provided. Beyond that, there is no specific rules about whether, who you can or cannot talk to with regards to a case.
Do you talk to defense lawyers?
Yes, I do.
And is it common for criminalists to speak with the person that's going to be calling them as a witness prior to getting on the witness stand and testifying?
Yes, and it's not only common, it's preferred. We want to make sure that everybody understands what's going on, that you have a chance to discuss the issues.
Let's get a little bit into the issue of collecting evidence. First of all, what does it mean from a criminalistic standpoint to collect evidence at a crime scene?
Well, collection involves everything from documenting where the evidence is, describing the item of evidence that's to be collected, the actual process of picking the evidence up off of the ground or off of whatever item it might happen to be, eventually packaging it and describing it for a property report, and then what's called booking it in or placing it into our property facility.
And when evidence is collected by criminalists at the Los Angeles Police Department Scientific Investigations Division, do you use some sort of form in the field for the purposes of doing that?
We have actually a couple different sets of forms. One of them that I believe is called a crime scene checklist, and the other is a vehicle search checklist.
Do you have that? I wanted to show you Defense 1107 for identification. Ask you some questions about that. It's the page, Your Honor, that is in table form. Chart form, I should say. Can you see, is the resolution good enough so that you can see that, Mr. Matheson?
I can see it, I can't read it, but I can see what it is and I recognize what it is.
Okay. And is that one of the pages in the crime scene identification checklist?
Yes, it is.
And is this page typically filled out contemporaneously with the evidence collection or with certain phases of the evidence collection?
Most of the information is, some of it is filled out later on.
Well, in terms of the numbers and measures, are those done at the time that the measurements are actually done or shortly thereafter?
Yes, I would expect it to. The item number along with a kind of brief description of what it is, such as red stain, coat, whatever it happens to be, along with the location of where it was found, if it was on the street or on a bed, and then measurements in the room or location if that's appropriate.
Now, are there any strict rules in the Los Angeles Police Department laboratory with respect to how this form is to be filled out?
No, there isn't.
And do you have a function now in reviewing these forms after they come back from the field?
Yes.
Now, with respect to the photo ID number column, or ID photo number, actually, excuse me, it just says ID photo. What is that to be used for, generally?
For me, I have always considered that a checkbox as to whether or not a photograph was taken of a particular item out at the scene. Sometimes it doesn't happen. Either photographer's not available, or whatever. I mean, that's been the place where I see, yes, a photo was taken, check it off.
Have you noticed any other practices?
I believe that there have been a couple people that use that as an indication of maybe a alternate number location if there was a different number used or something. I'm aware that people have different interpretations of what that column means.
And is there any requirement that you have to check off everything in that column?
Not at this point, no.
Okay. Now let's move the form over a little bit. And what about the by column? What is that to be used for?
My understanding of that is that's a spot where you put your initials, the person that was involved in collecting the evidence.
What if you're working in a team? How is that to be used?
Well, in the same way, if you have a couple of people out there and for some reason it may be important at some point to know who picked it up, it would be nice to have the initials of the person that was involved in it, but is not necessarily required.
And if you're working in a team and both people saw a particular piece of evidence collected, is there any standard practice with respect to whether you say the person that physically picked it up, its initials should go in there, or both people's, or how's that handled?
No, we currently don't have consistency on that.
Okay. And what about the time column? How do you use the time column personally?
Normally, I use the time column to bracket things. If I'm going to be, many times in the situation of picking up evidence, you go through and you locate the evidence, have it photographed, you put your numbers down, have it photographed with the numbers, do your measurements. You kind of work in groups of items in, say, a particular vicinity or locale at a scene. What I would do is record the time of the first item in a group that I pick up, a rough guess as to what time it is, look at my watch or something like that, and then I'd record the time of the last item in that group and just run a line between them. Sometimes I don't even record that information on this form. I've also been known to write it on the packaging or the envelope and then come back and fill that information in later.
So if you had 10 items, you would know, in that particular group, you'd know when the first and the 10th were collected with some specificity.
Roughly, yes.
And then everything else would just be an arrow between those two times.
A line, yes.
Do other criminalists use that in the Los Angeles Police Department?
Yes.
And are there other practices that are used?
Well, there are some people that record the time for each and every item that they pick up.
Okay. Now, from a serology standpoint, if you're talking about a stain that was collected at, let's say, 11 o'clock, and then a second stain that was collected at 11:15, is there any forensic relevance to knowing that one was at 11 and the other one was at 11:15 generally?
Objection.
To the phrase forensic, if you look at the foundation.
Vague.
Well, is there any significance from a serology standpoint to the time difference?
No, there isn't.
Okay. Now, within the forensic community, based upon your membership in these various organizations that you've discussed, are you aware of any consistent practice with respect to when you are working in a team investigating a crime scene, whether you should signify who physically collected a particular piece of evidence, whether you should separate it out?
I don't remember having any discussions about that.
That is not a hot topic within the forensic community.
No, it isn't.
All right. What about the issue of the times? Is that a hot? I'm sorry.
Did you locate that item? All right, Goldberg, proceed.
And what about with respect to the portion of the list that says time or notating the time, does that appear to be a controversial or hot topic within the forensics community as to how you should fill that kind of information out?
Not in specifically how it should be filled out.
All right. What is the goal that is the criminalist is trying to achieve in generating this paperwork? I mean, why do you even have to bother with it?
Well, the main reason is to be able to locate where the items came from. The most important piece of information that is on there, or the sequence of information that exists on that form, is the item number, the location where the item came from, and a description of the item itself. That way you can track that item through the system. Many of the other items that are on there are nice to have, but the most important thing are those three items: the number, the location, and a brief description of what it is.
So do those three items help you to place a particular piece of evidence back in the crime scene? In other words, figure out where it came from specifically?
Yes, it relates back to the photo that was taken of it, so you can see a picture of how it was at the scene, and gives you a location of, in general, where it was.
But if you have a photograph, is it absolutely necessary to even have this kind of information? I mean, isn't it duplicative to a certain extent?
Well, to a certain extent, but not completely. Photographs are not perfect in their depth or their perception as to where they are. It's still nice to have, measurements to generally locate it, where it is in relation to other items, in relation to a room, or in relation to a victim, something like that.
Okay. Now, is there any rule within the Los Angeles Police Department as to whether this form can be filled out in pencil or pen or any other writing instrument?
No, there isn't.
And with respect to erasures, is there any rule on that?
No, there isn't.
If the form is a mess to the point that it's difficult to read, can the criminalist rewrite it?
We talking about the whole form?
Or portions of it?
There's no rule that says they can't rewrite or clarify certain areas of a document.
Maybe we can just look at the next. 18 or 19. This is also 1107, Your Honor.
All right.
Have you seen this, taken a look at this document before?
Yes, I have.
For instance, on this document, if you wanted to clean it up to place it in numerical order, and because some of the items appear to have been erased and written over, is there any rule that would prohibit you from doing that?
Oh, well, but we have gone over this
Well, but
previously,
yeah, but it's something that the defense has made a lot of.
but we have
deal
gone
with that.
through it. We've discussed it. You can get his perspective as a manager, but I think we've about covered it.
I know, and it's just one
Right.
question on this, and
One
we spent
question.
about an hour on it during the defense case.
Wait, counsel,
Okay.
one question, proceed.
Could you repeat the question?
I hope I don't get in trouble. With respect to this type of form, if the criminalist wanted to clean this up because there are erasures or just to put things back in numerical order, would there be any rule against that?
There would be no rule with them rewriting it. From an administrative point of view, I'd like to have the original still thrown in with the notes. But if it made things clearer to rewrite things or reorder them, that would be fine.
But is there any written policy or oral policy on that one way or the other that you're aware of?
No, there isn't.
Okay. Now, you said that part of your function is to, currently as a supervisor, is to review, thank you, the crime scene identification checklist when they come back. Did you do that in this particular case? Did you review these?
Well, as when I was supervisor of the trace or serology unit, I also at one point was given the trace unit. One of my duties did involve the review of field notes as it related to crime scenes. These were not reviewed prior to their photocopying and distribution.
Why was that?
It was mainly a function of the hecticness of the time. We were involved both in this case and along with many other ones that go on constantly within the city. Mr. Fung does not work directly in our facility. He's in one of our satellite locations, and he had the notes with him for a period of time. And it was just a matter of circumstances that by the time we got copies of the original ones for distribution, they had not been reviewed at that point.
And who was supposed to actually review those while you were the trace supervisor? Was it supposed to be you personally, or did you have someone under you?
The normal process would be the notes would be left in a box in our trace unit. They'd be initially reviewed by our lead or the CRIM 3 of the field unit, and then he would give them to me with the recommendations of either filing them because they're complete or suggested things to advise the criminalist on when it came to maybe making them more complete prior to filing.
Did you have a CRIM 3 of the trace unit at the time that this case was, at the time that Mr. Fung and Ms. Mazzola went out and investigated the crime scenes?
Yes, I did.
Okay, was he at that time reviewing them, or were you doing it?
We were both doing it. He was reviewing the majority of them, but I was also involved in that.
Okay. And what is the purpose of reviewing them at all?
Well, it's kind of a twofold purpose. One of them, we are looking to see if they're complete or as complete as possible, that they have recorded things like field tests that were performed, mainly that they were as complete as possible. If there were areas that were left undone, we would send them back to the criminalist, and if he had that information available, we would ask them to make them complete. If they didn't have it, or you'd have to just make guesses on the information, we didn't want that. At that point, it becomes a training process in that we point out to them, next time maybe you should put a little more detail here, you should make sure your measurements are all included, whatever it happened to be, so that the next time they went out in the field, their notes would be more complete than they currently are.
So on occasion, you will ask someone to actually add something to the crime scene identification checklist to add some additional information?
I will if I am sure that they know that information, that they're absolutely positive and they're not just putting something in there to fill it in.
And other than that, the review process serves a training function.
That's correct.
Right. Now, on the crime scene identification checklist in this case, there's been some testimony that Andrea Mazzola was placed on as the officer in charge on the Bundy list. Her name.
I'm aware of that, yes.
Yeah. And is there any significance to that?
No.
Why is that done typically? What does that signify?
Well, the OIC or officer in charge, just normally by habit, is the person who is on call. Officially that weekend, Ms. Mazzola was the criminalist on call. When Detective Headquarters Division, which is the section of our department that dispatches us, has a homicide scene where a criminalist is requested, they go to a sheet that we supply them on every Monday and Friday and refer to the name of the criminalist that is available. And the name appearing on that sheet was Ms. Mazzola. She then, because of the fact that she was a CRIM 1, would call the CRIM 3 that was responding with her, the supervisor, in this case, Mr. Fung. So it merely was an indication of the fact that it was her weekend on call and her name was placed on top.
And that is how it's typically done? Is that what you're testifying to?
Yes.
All right. Now, with respect to collecting evidence again, do you have a practice, and when you're talking about biological evidence, of collecting representative samples?
Yes.
What does that mean?
To me, a representative sample is, well, probably the best way to do it is by a example. If you have a blood trail that leads away from a scene or into a scene or whatever, if you have a blood trail that consists of 30 or 40 drops that goes on for a block or two, it would be unnecessary and inappropriate to pick up every single drop of blood along that trail, because you can tell by looking at it that it's a continuous trail being dropped by the same person. What we would like to see, rather than picking up all 40 of them and spending the time doing that, is to pick up what we call a representative sample of that trail, a blood sample from the beginning, maybe one or two in the middle, depending on how long it is or more, and one from the end. I would also expect somebody that's doing a trail like that to collect any sample that appeared that it was out of place or not consistent with the trail. That's my definition of what a representative sample from a crime scene is.
And what about in a situation as in a car like the Bronco in this case? Do you have to collect every last stain in there, or do you take a sample of them? How do you do it?
It depends on the quantity of blood that's present. If there are a number of stains that are grouped together, then I would say no, you probably are not going to collect every single one of them. I would expect somebody that's doing a car search would pick up samples from different areas within the vehicle that represent the possibility of different blood samples coming from different individuals.
And what is the purpose of taking representative samples in situations like the ones you've talked about, as opposed to just collecting every last stain that's there?
Well, we deal with realities when it comes to resources. We have only a certain number of people that are available to collect evidence and a certain number of people to analyze evidence. And at some point, you have to be practical. You have to decide that you're spending too much time picking up every one of these 20 samples, where that time could be better spent evaluating other parts of the scene, getting the samples packaged and ready to go. And then ultimately, when it comes to the serology unit, they are not going to analyze all of those items as a rule anyway. They are going to have relied on the person at the scene to pick up the best samples, the ones that will be most representative of the crime and the people that were involved. And it's the best utilization of the resources so that we can get as much provided for the people of Los Angeles as we can with the resources that we have.
Can you judge how well a criminalist has done in terms of processing or investigating a crime scene with biological evidence by figuring out the quantity of stains that he or she collected?
No, we have had some people that collect very few but always seem to find the most probative samples, and we have had people in the past that collect many, many samples but don't always give us the best information.
When you say most probative, you mean what?
Ones that answer the questions, ones that if there's multiple people bleeding at a scene, that we are getting blood from multiple people and not just from one. Whatever is necessary to get the most appropriate or the best information out of the evidence that's left at the scene.
Now, is this idea of using selectivity in collecting evidence one that is discussed in some forensic science literature?
Yes, I'm aware of it being discussed elsewhere.
And specifically, did you look at the discussion of this idea in Henry Lee's book on crime scene identification, the one that I always refer to as Henry Lee Child Edition?
I have seen that information in his book, yes, that you need to be selective in the samples that you collect.
And I'd like to just show you one portion of this book and see whether you've taken a look at it. It just has big print. That's the big print book. You recognize it?
Yes, I do.
Yes, child.
What?
Referring to the page, referring to the size of the print.
Referring to the size of the print. It's big print. It was my idea of a joke. But anyway.
You're obviously not at the age where you need bifocals.
Yeah, that's, well, I'm getting there.
You may.
And directing your attention to page 79, the first full paragraph. Maybe you could just read. Have you considered that paragraph? Have you read that before?
Yes, I've read it before.
And maybe you could just read what Dr. Lee says about collecting evidence where it starts recognition and, well, maybe just starting there through the rest of the paragraph.
Recognition of evidence involves selectivity and a general understanding of logic of crime scene. If all objects at the scene are collected and submitted to a forensic laboratory for further analysis, the forensic facility will be overwhelmed. If critical evidence is omitted or improperly preserved, the use of sophisticated equipment cannot salvage the investigation. Hence, correct crime scene search and collection methods are of paramount importance.
Okay, so basically it's a balancing act between not wanting to overwhelm the laboratory with too much and not wanting to miss the relevant evidence.
That's correct.
Now, with respect to the Bronco, well, I'll get into that later. Have you heard some testimony to the effect that in this particular case that there were 5 stains at the Bundy location, all of which were collected, whereas there were 3 stains at the Rockingham location, A, B, and C, that were not collected?
Yes, I have.
And is there, from a forensic science standpoint, in terms of crime scene identification, based upon your understanding of the evidence in this case, any reason for that?
There's my understanding of it, yes, there's an explanation for that.
What is that?
Well, in the case of the items that were collected from Bundy, that was the crime scene. We had 2 victims there, and there were blood droplets that appeared to be inconsistent with having come from either of the victims. So they would indicate somebody else that had been present at that location. At that point, it makes sense to collect as much as possible of that, keeping in mind what I said before. If it had been extremely long, I would have expected them not to collect all of them. But to collect a good representative sample of what we have there as far as the blood goes. As far as the other location at Rockingham, that was not a crime scene. It was another location that may or may not have been involved. And they used a little bit more selectivity there, collecting a stain at the beginning, at the end, and leaving some of the ones in between in place.
Your understanding is that there was no body or evidence that a crime actually occurred at that location?
That's correct.
Sustain or phrase the question.
Is it your understanding that there was no body or evidence that a crime actually was committed at that particular location? Homicide.
Sustain.
Oh, it's okay. I'll withdraw the question. Now, did you also hear some evidence to the effect of I'm not sure if it was triangular, but a little corner piece of paper that was in the area of the entrance to the caged-off area not having been collected?
Yes, I have.
And what is your view on that?
As far as I'm concerned, if the
Object to that question being pulled.
Sustain.
Should that have been collected,
yes.
and why?
The area that we were talking about as far as this crime scene goes is a fairly limited in size, and not like, again, using an example, if the crime had occurred in an alley where there was a lot of debris, a lot of trash around, then some selectivity should have been done as far as collecting. You're not going to collect every bit of paper, every bit of trash that's in an alley. This particular area, though, was smaller. I would assume had some maintenance done on it with some regularity, possibly cleaning up. A piece of paper in that location kind of stands out as being potentially involved somehow, and had the criminals been aware of its existence, should have collected it.
Okay. And could the failure to collect that item have in any way affected any of the other biological evidence, some of which you tested in this case?
No, not in any way.
Okay. Do we... Just get a picture, I'm sorry. While they're looking for that, let me go on to another topic, and then we'll come back to it. Does the Los Angeles Police Department use plastic baggies or plastic bags for the purposes of putting the wet swatches until they've had an opportunity to dry them?
The plastic baggies are used to transport the evidence, yes, until they can be taken back to the laboratory, opened up, and allowed to dry.
And how long has that procedure been used?
Well, that's the one that I learned pushing 17 years ago, so it's been in use at least that long.
And during the 13 or so years that you were involved in the serology, is that right? Was it approximately 13?
Yes, approximately 13 years.
What effect, if any, did you observe on that collection technique, on the evidence that you were actually testing?
Well, considering it was the technique that was used and was a standard technique in our laboratory, and we would, with regularity, analyze evidence items that would give us good typable or identifiable results, I would have to say that, that the use of that technique was appropriate and effective for bringing samples into the laboratory for analysis.
And during the 13 or so years that you were in serology, did you notice any particular problems in terms of evidence being degraded to the point where you couldn't get results?
No, there is not an ongoing problem at all with degradation that I can relate back to the bags. Occasionally, we would have a piece of evidence come through that had been allowed to stay in the bag, and that's very inappropriate. And that would show us problems with that evidence.
Under what circumstances would that happen?
If the person forgot to take it out, if they were not properly trained, that would happen sometimes with the detectives. It just is a situation that would occur, though, very rarely.
Sometimes when detectives were collecting some of the stains.
Occasionally, but rarely.
And in those instances where it was not taken out of the bag to dry for an extended period of, well, when you say extended, what do you mean?
Well, I mean, as far as ultimate packaging, where it then gets put onto a shelf and is left for, anywhere from many days to months.
You mean you would have situations like that occasionally with detectives?
Where we'd see a blood sample still left in a plastic bag?
Yeah.
Occasionally, but rarely.
And what happened on those samples?
Normally, they were degraded. You wouldn't get false results. You'd just get no results.
What do you mean you wouldn't get false results?
Well, except for a very unique or specific situation, degradation of a sample doesn't change the type to another type, just makes it so you don't get any information at all.
So when you say no information, when you do your test, what do you come up with?
No result. There's no typeable result that's obtained.
So in that particular instance, if the perpetrator's blood has in fact been lifted from a crime scene or a crime location, and the results have been degraded to the point where you don't get any information, would that benefit the perpetrator?
Sustained. Rephrase the question.
Would that cause the perpetrator to be falsely included as a possible donor of the stain?
No, it would not.
Could it cause the perpetrator to be falsely excluded?
No, there's no information there at all. It just wouldn't provide any forensic information.
Okay. Now, let me just go back to this photograph. I think I'd like to mark this photograph as People's 205 for identification of what appears to be the little piece of paper. I think it's depicted in some other photographs.
Yes.
205. Is this your understanding of the piece of paper?
Yes, it is.
Okay. Can we see that? All right. And is this piece of paper, you said that you would have collected if you've been out at the crime scene?
If I was aware that it was there, yes, that's one of the items I would.
Assuming it hadn't been covered over by a blanket or some other item, and you'd seen it.
If I'd seen it, yes.
Now, Is this the kind of thing where there's a hard and fast rule that you should collect it, or is this the kind of thing about which reasonable forensic scientists could differ? I mean, how would you characterize it?
Well, when it comes to what to collect, there are very few hard and fast rules. That's what is acquired with experience, the mental picture of what you collect and what you don't collect. So as far as a hard and fast rule, whether or not somebody should collect it or told to collect it by a manual, no, that doesn't exist.
Okay. And in your estimation, Mr. Matheson, if this particular piece of paper were located in an area where there was fairly extensive pooling of the victim's blood, would this be the kind of evidence that you would want to test for biological evidence showing the victim's blood type?
I don't believe I would recommend this particular item to be tested for the biological evidence on it, particularly in light of other evidence that was collected.
Okay, thank you. Now, going back to the issue of collecting, why would you not recommend that that be collected for, tested for biological?
Phrase that.
Why would you recommend that that piece of biological evidence or the biological evidence on it not be tested further for genetic markers?
Well, like I just mentioned, you have to look at the whole scene, and we do have other items of biological evidence that provide information as to what possibly occurred. This particular one being found in close proximity to the victim, being heavily blood-stained, at some point we do have to make some assumptions, and the assumption would be that the blood that's present on that is coming from the victim herself. At some point, if it really seemed necessary or if there was a lack of other evidence in the case, we may want to go after and analyze some of the individual drops, but it would be a low priority when it comes to that.
Just wanted to show one of the overall photographs of the crime scene that's already been marked. Show him equal to 60 to 1. It's 43. And I guess this is it's a bloody photograph, but so the court might want to cut the feed. Sir, showing you what's been previously marked as People's 43D. In this area of the pooling of the blood, how much, if any, of that blood on the sidewalk, it's not a sidewalk, in this walkway, should be tested?
On that particular location, very little of that blood. It is common sense does come into play when you're picking and choosing which items to analyze or which items to collect. And common sense would tell you that by far, if not all of the blood that's visible in that picture is coming from the victim herself. I would want at least one sample or item of that blood to be collected as a standard of the victim. But
And if the evidence showed that the piece of paper were found in what would be the upper right-hand portion of the photograph, would that location be consistent with the answer that you previously gave about why you would not want to test that necessarily for biological evidence?
that would be the
Sustained.
Is there anything about the photograph and the placement of the object that would relate to your answer previously given us to testing the piece of paper for biological evidence?
Well, given the location of that piece of paper and the way it's heavily stained, I wouldn't say that we'd never test it, but it would be a very low priority.
Okay. Thank you. Now, getting back to the issue of collecting stains, have you looked at the Los Angeles Police Department manual, specifically Section 52520, as to booking of biological evidence?
Yes, I have. I've looked at a number of manual references. I'd like to make sure that the one you're talking about is the one I'm thinking of.
I'm just going to show this to refresh the witness's recollection. So showing you a section of the Los Angeles Police Department manual. Do you recognize that?
Yes, I do.
And specifically 52520 talks about preserving wet stains.
Yes.
And does that state in the second sentence that plastic containers or plastic wrap shall not be used as a packaging material?
Yes, it does.
What is your understanding of that requirement?
Well, the operative term there is packaging. We teach, and in consistency with the manual at that point, say that biological evidence should never be stored or packaged for permanent storage in plastic.
Now, when you say packaging, final packaging, what are you talking about?
When the items are submitted to our property division for storage until such time they're analyzed.
Okay, I'll get into that a little bit more later. So, in terms of the usage of plastic bags for transporting a stain from the scene to the laboratory when it's dried, within the forensic science community and amongst serologists, is that one acceptable technique for collecting a stain?
Yes, it is.
Now, does the Los Angeles Police Department, let me just ask you another question about the manual first. Is this manual, the manual provisions dealing with the booking of evidence, are they up to date?
No, they are not.
In what manner are they not up to date?
Perfect example is we currently have within part of SID a property room that's called the Evidence Control Unit, and we have a courier system, which are light duty officers that travel throughout the city at night collecting evidence from the different stations and bringing them down to our Evidence Control Unit for final storage. Both of these functions have been in existence for at least, well, I believe 2 to 3 years, one of them longer than that, and there is no reference to either one of them that I'm aware of in the manual.
In other words, there's no reference to this new evidence control unit that you have at SID in the manual?
That's my understanding, yes.
Okay. And if a piece of evidence is collected from a crime scene, biological evidence, in a manner that's forensically accepted, but the manual provisions have not been updated in such a way so as to authorize that particular collection, would it affect the outcome of the test?
Well, first off, I'd rather they followed the proper procedure rather than following the manual.
Okay.
If that is the way that we're doing something, then it's better to use a procedure that's going to give you the best results than a reference in the manual that may be outdated.
Now, with respect to the crime scene truck, is there a refrigerator in the crime scene truck?
Yes, there is.
And what kind of materials are stored in the refrigerator?
Mainly it's chemicals, particularly chemicals that we use for field spot tests.
Would there be any problems in storing biological evidence in the refrigerator?
Any problem with it?
Yeah.
No, there isn't a lot of space, but there wouldn't be a problem with it.
What about spillage? Is there any issue concerning spillage of these chemicals onto the biological evidence?
Well, ultimately, that could be a problem. But we don't have a lot of spillage in them, but we do carry chemicals in there.
Now, is there any rule that you're supposed to use the refrigerator when you're collecting a stain?
No, there is not.
And what about with respect to the whole blood? When whole blood is collected and a criminalist comes into possession of it, does that whole blood that's taken as a reference sample have some preservative in it?
Yes, it does.
I'd just like to show you what's been previously marked as Defense Exhibit 1112, and 1124 for identification, two purple top tubes. Do you recognize those items?
Yes, I do.
What are they?
They are two samples of two different brands of blood collection tubes.
What's the significance of the purple tops?
The color of the top of any tube indicates the preservative or anticoagulant that's present inside of the tube. Purple happens to pertain to something that goes by the initials of EDTA.
Do you use purple top tubes in the laboratory?
Yes, we do.
And do they come from the manufacturer with the EDTA in them?
Yes.
What does it do?
I'm not sure if it is just a anticoagulant or if it's an anticoagulant preservative, but it helps the blood to stay in such a condition that it's appropriate for typing.
And is it critical if you have an EDTA purple top tube to refrigerate that reference sample immediately?
Not immediately.
Okay. How long can you keep the purple top tube out, or should you keep it out before you refrigerate it?
Well, I don't know if I know of any particular, specific time frame. I would like, personally, I would like it to get into a refrigerator as soon as it's possible. However, I do know that we get legitimate results if it's not placed in the refrigerator as soon as possible. So I don't think I can give a specific time frame on that.
What happens if you get a reference sample from a living victim or a living defendant? The defendant has to be living. And the activity from the tube is lost, genetic activity.
Well, in that situation, it creates a little bit more paperwork, I'm sure, but the source of that blood is still available. We can get an additional too.
Okay.
All right, Mr. Goldberg, would this be a good spot?
What? Maybe I could just ask one more question to tie this up. Okay. And what is the effect, therefore, if the genetic activity is lost from one of these tubes?
Well, if it is lost, then the information from that particular tube is no longer available to us. However, if we can get an additional sample from that individual, the results would be exactly the same as from the first tube.
And what if you couldn't get an additional sample from the individual? Would you get a false inclusion as a result of a blood vial having degraded?
No, you wouldn't get a result. There'd be nothing to compare the information from your evidence items to compare it to.
Similar to the case of a dried stain taken from a crime scene?
It's a stain.
Well, is that similar to the explanation that you previously gave when we were discussing a stay and take it from a crime scene?
That's correct, in that if you lose the information, there isn't anything there to compare to. You do not make then erroneous comparisons, inclusions or exclusions.
And in this particular case, were you able to test and get results from the reference sample that came from the defendant?
Sustain.
Did you test the reference sample, in this case, item number 17?
Sustain.
I didn't hear grounds.
Foundation.
Okay, I'll take it up. Maybe we can take it up.
All right. The person whose cellular telephone went off is ordered to immediately surrender that telephone. In this section of the courtroom. If I don't get a response from anybody, everybody's going to be searched coming in and out of the courtroom for the presence of cellular telephones and pagers. We've had enough problems with this. We've disrupted these proceedings 6 times already. I don't want to have to order the bailiffs to search each individual person. So the person with the cellular phone,
There was a couple space back here and one here, and they left already, they've gone.
their purses were searched when they left.
Oh.
All right, bailiffs are ordered to search each individual entering the courtroom. No pagers, cellular telephones, any noise-making devices may be allowed in the courtroom from this point hence. All right, we'll be in recess, 1 o'clock.
Courtroom quietly.
Simpson matter, all the parties are again present. Mr. Blazier, when we recessed, you indicated that there was something about, we had one other issue, one of the boards that you had an objection to.
Actually, now there are 2 issues, Judge. They just brought another board in.
All right, well, let's take a look at the first board.
The fingernail board.
Is it okay with the information seized in this manner? So it's
Yes.
Father, Jesus' name I ask to open the heaven and pour out their peace and strength in here.
Exhibit 42, which bear the frame counter number 0039. This bears the frame counter 0040. You see the two photos.
No, I recognize the scene that's depicted there. All right, Mr. Goldberg, why do we need this?
What?
Why do we need this?
The reason is that this goes back to the EAP issue. As the court recalls, the defense made a big deal in the opening statement about someone else's blood being found under Nicole Brown's fingernails, and we're going to address that in some great detail. The court knows that one of the things that we want to do in order to do that is to put on evidence as to the testing of item number 42, which is the blood underneath Nicole Simpson, Nicole Brown. And what I want to be able to show here is why it was reasonable from a forensic science standpoint to make an inference about the results under the fingernails from the results on the pool of blood. I want to show that they are in contact, that she is lying in that area, and that the blood that Mr. Matheson tested, item number 42, is subject to the same environmental conditions and was deposited on the crime scene at the same time, presumably, as the blood underneath the fingernails.
So you're saying the relevance is the location and position of the hands from whence the nail scrapings come?
Yeah, in contact with the pool of blood. And then the relevance of the hands themselves is the close-ups of the hands, which I believe may also be in evidence, according to Mr. Glazier, is that they do the same thing. They're showing that this is all really part of one contiguous and continuous blood source, and therefore we can take test results from a variety of locations in that source of blood under the fingernails and interrelate them and trying to figure out what's happening to the items underneath the fingernails.
All right, Mr. Glazier, do you have any response to that?
Just that the jury has seen these pictures over and over and over again. You can't even see item 42 in any of these pictures. I think it's irrelevant and cumulative and prejudicial.
All right. The court finds that in this particular context, the location and position of the hands relative to the crime scene itself, the pool of blood, and the location of Nicole Brown Simpson as she was found, that there is significant probative value with regards to the nails, clippings, and scrapings, and that the jury has already seen a similar picture to this in a relevant context. I don't think it will have the inflammatory effect that counsel argues, so the objection will be overruled. All right, what's the second board?
There's a new chart that just was brought down at 1 o'clock, I believe, and it concerns testing by the defense. And this is an issue that we've talked about a number of times before. We're waiting for a ruling from the court on issues related to these items on this board, I believe. And we have items during the period of time when we had possession of them. There is virtually no probative value. Clearly, there's a prejudicial effect to what they want to do. We strenuously object to any testimony concerning what happened to items when they were in our possession or what didn't happen to items.
With the court's permission, maybe Mr. Harmon could address this because he's going to use this with one of his witnesses and mine in order to establish the authentication for the exhibit.
All right, let me ask you, though, Mr. Goldberg, before you go, one question. When do you anticipate using this?
I'd say I probably have about an hour and a half worth of material to cover to 2 hours is my best guesstimate prior to this board.
All right, Mr. Harmon?
Your Honor, remember we proposed the stipulation that would accomplish what this board accomplishes, and it's kind of disappeared from everybody's agenda. This board is our attempt to utilize the provisions that you made in your order on February 8th. They would like everybody in the world and this jury to think they never tested any evidence in this case, and that's simply not the case. They took part of our samples in October. They did not have writing on them. That was pursuant to the court's order. Mr. Matheson can lay the foundation for that being turned over. When they came back, they had all these names and dates all over them, and that's the subject of what we're going to discuss Wednesday afternoon, but it's also contained in the stipulations. And so, absent them stipulating to a very sanitary, you took our evidence, you brought it back, you consumed part of it in the testing, which is what you afforded us the opportunity to do. We have to prove it. And this is one way that we begin proving it, Your Honor.
Mr. Blazier?
The critical phrase there is consumed in testing. We've stated from the beginning we have no objection to the jury being told that the reason there's a half of 3 swatches missing is because it was provided to the defense. The jury needs to know nothing beyond that. Mr. Harmon wants to get into what we may have done in a confidential, privileged basis where he wasn't there. He doesn't have the foundation to go into that. He wants to raise some sort of specter that because we've tested evidence that we got results we didn't like, which is not.
So your objection is characterizing it as having been used in testing rather than just having been given to you for whatever purpose you deem appropriate.
Correct.
So if the court's instruction to the jury is that on such and such a date, this item, for example, item 47, the possession of which was given to the defense, that a certain portion of that was removed and given to the defense, and then the remainder returned to the prosecution on a subsequent date, you have no objection to that?
No problem with that at all.
All right, then you would have, I take it, then no objection if that is the limitation on the testimony here with regards to these packaged items.
Well, I would object to the introduction of these large photographs of the packaged items with all sorts of different signatures on them that presumably Mr. Harmon is going to feel the need to explain to the jury where they came from. Nothing is added by this chart that isn't conveyed to the jury by what you just said, what the court just said.
All right, Mr. Harmon?
Well, we've been pussyfooting around with this for months now, Judge, and every time, we tried to make it in a direct, very sterile way, and then they dodged it, then they filed this prosecutorial misconduct when any fool can read what happened to these things. And now when we're about to prove things, which is what the jury trial is about, now they want you to just tell them something. Well, I'd rather that we're not asking for a stipulation. We're not asking for an instruction. We're asking to explain the factual history of what happened to these samples. And whatever legal instruction you give at a later point, I'm sure will comport with the process or the due process requirements that we can't comment on the defendant not testifying or them not presenting any evidence. But this is the factual history, the chain of custody of these things. And we've tried in many ways to resolve this. And now, when it comes time through the logical witness to begin the proof process, now they want you to just tell them something that's just not quite true, consistent with the factual history of these things. I think we should just prove it, Your Honor.
All right, thank you, counsel. I'll contemplate that. Mr. Goldberg, let me know when you're about to launch into that. We'll take a break, and I need to look at 2 cases before I rule on this.
Thank you.
All right, let's proceed.
One other quick issue, Your Honor. Mr. Goldberg showed us some papers, some handwritten lab notes this morning that we have never seen before. He indicated that he thought they had been turned over. Mr. Scheck and Mr. Neufeld and I have never seen them. We don't yet have copies of them. I would ask that we be provided with copies and that he not elicit any testimony concerning these documents until we've had a chance to explore them and find out why we didn't get them in a timely fashion.
What are these things, Mr. Goldberg?
Your Honor, these are not lab notes. This is an item that was generated on 6/29/94, which are the handwritten copies of the inventory that was done, that was the subject of the Griffin hearing, and that was subsequently generated in a typewritten form. Counsel says that he does not have it in a handwritten form, but I believe that the handwritten copy of this was introduced at the Griffin hearing itself as an exhibit, as Exhibit K to that hearing. But he is correct, it does not have L numbers or D numbers, but if they went through the Griffin hearing materials, they'd find that this is, as I said, Exhibit K.
All right, Mr. Goldberg, are you going to get to any information on that at this point for our next recess?
I could, and as I said, it's identical to, well, I'll probably get to it sometime around when we address the photographs that are the subject of the court's other pending.
All right, is there an item K from the August hearing? You pull that out, Mrs. Robinson.
But at any rate, it should be identical to the typewritten one that was generated from it.
Was that during Mr. Matheson's testimony?
No, I believe that was during Ms. Kessler's testimony.
How many pages are these handwritten notes, Mr. Goldberg? Is this the 11 pages?
That's correct, Your Honor. By Mr. Scheck.
All right, item K in the transcript, in the list of exhibits at page 6, transcript of August the 23rd indicates item K are handwritten notes, 11 pages, dated June 29, 1994. And the testimony was that these were then converted into the computerized, computer-generated printout. And they were, as you indicate, marked by Mr. Scheck for the purposes of that hearing. Mr. Blazier?
Well, I wasn't aware of that. I know that they're not in the lab book. These are handwritten notes that we were under the impression we were given all of the handwritten notes prepared by people at SID. I don't believe those are in any of the discovery documents. Whether they were provided at the time of that hearing or whether Mr. Scheck got a copy, I'm just not sure. But I know there is a typed document that
All right.
presumably mirrors that.
Well, it appears that Mr. Scheck had them for the use at the Griffin hearing, so the argument that you haven't seen these before, I'll have the staff make you a photocopy of what Mr. Goldberg has. Do you have any additional copies, Mr. Goldberg? Mr. Goldberg, do you have any additional copies? All right, would you give that to Mr. Byrne for me, please? Mr. Byrne, would you make some photocopies of that? All right, let me know before you get to that particular document, and we'll get a copy for counsel. All right, let's proceed.
Also, we had a number of foundational objections right before lunch that
That's correct.
We need to resolve.
All right, what's the nature of your objection, your
Yeah,
foundational objection,
Mr. Neufeld has prepared the brief on this. Ask that he argued that if possible.
Well, you're the one presenting the witness, counsel.
Well, we strenuously object to have Mr. Matheson testify about the results of any testing conducted on Mr. Simpson's reference sample without a proper foundation being established, and that foundation being testimony by the nurse who drew it, the manner in which it was drawn, how it was preserved, how it was logged in, how it was packaged, and how it got to the point where he performed testing on it. The foundational question, as the court is aware, we're raising serious questions about foundation, chain of custody, packaging, collection.
Do you have any argument that's not included in Mr. Neufeld's written argument?
No.
All right. Mr. Goldberg.
Well, Your Honor, on page 19367 of the transcript, it's volume 110 of Detective Van Adder's testimony. He did testify to seeing the item drawn, to the defendant being in the jail dispensary and blood sample having been drawn, and that he then took that blood sample and dropped it off to Mr. Fung at the Rockingham location. Actually, the chain of custody on the blood sample has been more thoroughly explored in this case prior to Mr. Matheson's testimony than any other exhibit that I can recollect in any of the previous trials that I've been involved in. I mean, we've gone into this for hours and hours and hours, and we have testimony leading from the time that it came out of the defendant's arm to the time that it was packaged up in the gray analyzed evidence envelope and booked. That's the first argument. So just simply factually, the defense is wrong. The second argument is on order of proof. The court has complete discretion with respect to the order of proof and how witnesses are going to be called. If we were to require a chain of custody to be done on every item prior to the witness testifying to it, then we would not be able to get into evidence of the fingernail scrapings, because we haven't heard from the coroner yet, or the clothes that came from the coroner on which some testing was done, which we clearly can do. And we would not be able to present evidence on the victim's reference vials, which came from the coroner. A lot of these things have to be tied up later. And we also have a situation here where items of evidence were exchanged back and forth between Cellmark and the Department of Justice. So how would you do that? I mean, one of those organizations has to testify first. So if Cellmark testifies first, they're going to be testifying to items, some of which...
Let's look at the item that we're talking about here today.
Well, the point is, Your Honor, is that there are dozens of items, the chain of custody of which is going to be proved through other witnesses, whether they're coroner's witnesses, whether they're DOJ witnesses, whether they're Cellmark witnesses, or whether they're other SID witnesses. We also have...
I'm not interested in that issue or that argument. I'm just interested in this blood vial, this particular situation.
And that's what I'm trying to address is order of proof, which is contained in Penal Code Section 320, which says that except as otherwise provided by law, the court in its discretion shall regulate the order of proof. And we just know that the case law is replete with instances where courts have virtually absolute discretion in doing this. This case has to be presented or should be presented in some kind of orderly way. And we could call a lot of witnesses twice. Once for chain of custody and then for their respective tests. It doesn't make any sense to do it that way. So certain aspects of the chain of custody will have to wait until later to be proved. So that's the second argument. The third argument is a business records argument. We have the case of People versus Aguilar, which I cited which was cited in the points and authorities that we prepared. And stands for the proposition that you can prove a chain of custody of narcotics evidence of a police officer that was deceased by his notations on the evidence package. As the court is familiar, evidence packages typically contain a chain of custody statement where the police officer fills out what he did with the chain of custody of the item. And that was held to come in under as both an official and business record. In this particular case, Mr. Paradas filled out that same type of chain of custody statement, which is in the pictures, the photographs of the analyzed evidence envelope.
Has Mr. Paradas been
withdrawn?
Has Mr. Paradas been withdrawn from the People's Witness List?
No.
And he will be testifying?
He may be testifying at some point.
Isn't that something I need to know now?
Well, the issue is one of chain of custody. And the issue is one of foundation. And the court asks, is that something the court needs to know now? we believe that
No,
that issue.
your argument is order of proof. You're telling me that you don't need to call this guy right now.
Right, and if the court concludes that we do need to call him at some point, we absolutely will, obviously. We're going to do whatever needs to be done in order to establish a chain of custody of these items.
So it implied in your order of proof argument is that that person will be coming sometime during the case in chief.
Or may be coming at a later time if the court so orders, or if the
Later
court
than-
so finds.
Later than the case in chief.
Well, no, later in the case in chief.
Okay, all right.
But the first argument, as I said, Your Honor, is that we don't need to call him at all legally because we've established it through an eyewitness, Detective Van Adder. And the third argument is that we don't need to do it because we have the business records and we have a case that's on point that says that the chain of custody statement on the envelope does qualify as an official record.
All right, Mr. Blazer, any brief response?
This is not a chain of custody argument. This is a foundation argument. We would ask the court to use its discretion, which we accept the court has, to say this is important. This person should be on first to establish the foundation before Mr. Matheson testifies about test results. Mr. Pradas was on their witness list. He was going to be called before Mr. Matheson until the people changed their mind a week or so ago. We would ask that that be done first, and that the court not allow the prosecution to suspend this witness's testimony or Mr. Pradas' testimony for some indefinite time in the future.
All right. Thank you, counsel. I agree that I believe also that the court has not unbridled, but certainly wide discretion as far as the order of proof is concerned. I will allow Mr. Matheson to testify to these matters subject to a motion to strike if Mr. Pradas is not called as a witness. All right, let's proceed.
Just for the record, is the court rejecting the people's argument about Detective Van Adder being an eyewitness to the drawing and transmittal of the blood?
I'm saying,
Or is the
no,
court
I'm not
not?
rejecting that as testimony, but there are other things that perhaps are missing in the foundation. Medically approved method, use of a particular file, who knows? I haven't examined Detective Van Adder's testimony from months ago.
Yeah, I just wanted to mention the court wasn't ruling on that issue.
All right, let's have the jury, please. All right, good afternoon, ladies and gentlemen. All right, the record should reflect that Mr. Gregory Matheson is again on the witness stand undergoing direct examination by Mr. Goldberg. Good afternoon, Mr. Matheson.
Good afternoon.
You're invited, sir. You are still under oath, and Mr. Goldberg, you may continue with your direct examination.
Thank you. We were talking about EDTA vials and not refrigerating them. Can you give a simple explanation as to what happens if a vial were not refrigerated for a lengthy period of time and the material degraded? What happens?
Isn't that question kind of vague, lengthy period of time?
Okay, well, let's say that it's not refrigerated for a long enough period of time so that the material degrades, however long that is. What happens?
Well, as far as an analogy or an explanation, it's similar to the degradation of any form of biological evidence or sample. I like to use as an example when it comes to field evidence, which could then I suppose, be carried through over to a blood vial that was improperly stored. It's just like having a piece of meat or any other sort of biological entity. If you leave it sitting out on your counter, eventually it's going to rot to the point where it's going to be unusable or go bad. In the case of biological evidence or a blood in a blood vial, eventually under improper storage conditions, the components within it are going to rot and break down and become unusable for forensic purposes.
Okay, when you say unusable, what do you mean?
That when we use those items in our testing, we will get no results.
But does the degradation that takes place or can take place in a blood vial, is it going to change the nature of the blood so that it appears to be someone else's?
Well, as a rule, it won't change. It'll just go to the point where you cannot get any sort of result. There is one exception to that, but as a rule, it will not.
Okay. And when you say one exception, I don't want to go into this in detail right now, but are you talking about one particular genetic marker?
Yes.
Okay. Now, excuse me. When you ship biological material out to an outside laboratory, is it shipped in a frozen condition?
No, not at this time. We place them into like a Federal Express or something like that, overnight pack, and ship it.
So there may be as much as a 24-hour period of time that it is not frozen as it's being transmitted?
That's correct.
And what is the effect of that?
It doesn't appear to have any. We originally, when we started submitting evidence for DNA analysis, used to package them in cold packs and created very large containers. And we got away from that and have not noticed any change in the results or, the quantity of positive typing results that we've obtained.
All right. And were you, in fact, able to perform conventional testing to determine the genetic markers on the reference sample, item 17, in this case?
Yes, I was.
Now, going back, continuing on with our evidence collection questions, when evidence is being collected at a crime scene, do you use clean instruments or sterile instruments?
They're clean, not sterile.
And is it sufficient to use clean instruments?
Yes, it is.
What's the distinction between clean and sterile?
Well, in the case of a sterile instrument or something, it's been autoclaved at a high temperature to remove absolutely every little bit of any form of biological material, or to render it useless in essence. They're sterile. It'd be like in surgical instruments and that type of thing. Clean is a matter of wiping them down using what we call a chem wipe, which is a kind of a scientific tissue, and a little bit of water or something, wiping off all the residue that's on it.
And is it accepted forensic practice to use clean instruments as opposed to sterile in the field when you're collecting biological samples?
Yes, it is.
Have you ever noticed any problems with that in the years that you've been in serology?
Sustain, rephrase the question.
Have any problems been encountered as a result of using clean instruments in terms of contaminating samples?
Objection. Lack of foundation.
Sustain, rephrase the question.
Sir, when you use clean instruments, do you use the clean instruments to pick up the control and the swatch?
Yes.
And if there were a problem in using a clean instrument, would you expect that to show up somewhere in the testing?
Objection made.
Overruled.
Well, that's one of the reasons you take a control, is you're handling it in the same way as you are the evidentiary blood stain or whatever biological stain it happens to be. And if there was a problem in using clean rather than sterile, I would expect to see an ongoing problem with results showing up in our controls.
And have you noticed any such problem in the years that you've been in serology?
No.
What about changing gloves between the collection of biological specimens? Is that something that's necessary?
Not between everyone, just as a matter of course. I would expect somebody to change them if the gloves got particularly dirty or bloody from handling something, but just to say you have to change it between every item, that's not necessary.
Why?
Well, for one thing, you want to be using techniques that limit as much handling as possible with that item. Whether you're wearing gloves or not wearing gloves doesn't mean that you're going to be grabbing the item in inappropriate ways. You are trying to limit the amount of contact that you have with it. And as a rule, even with gloves on, your gloves never come in contact, particularly when you're talking about swatching blood stains or something like that, come in direct contact with the evidence item itself. So there would be no need to change your gloves in between.
Would it be possible to collect stains from a crime scene? Well, of course it would be possible, but could you collect stains from a crime scene without using gloves?
If you use good practice and not handle the evidence or not allow it to come in contact with your skin, sure, you could do it without gloves.
Would there be some health concerns in doing it that way?
That's true. I mean, that's one of the major reasons for wearing gloves and a lot of this protective equipment is to protect the operator from the evidence as opposed to the other way around.
And if there were some problem at the crime scene where a person were collecting the evidence by touching the swatches with their hands instead of using tweezers, could the controls detect whether that had caused contamination?
If somebody chose to collect bloodstains by just using their fingers and then chose to use the exact same technique on the controls, that's one of the reasons for the control, like I mentioned before. If the technique is the same and you're transferring information or biological material from your own hands onto the evidence, you'll also then be transferring it onto the control, and I would expect the control to show that.
Okay. And let's say that you decided to use this technique, if you want to call it that, of just collecting the evidence with your hands as opposed to tweezers. Would that be an improper technique in your judgment?
Yes, it would be improper.
But would that improper technique cause the blood at a crime scene to somehow change into someone else's blood?
No, it's not going to change it anyway. You may be adding additional information to it from your own biological material, but it wouldn't change what's already there.
And similarly, on the tweezers example, where we were talking about clean versus sterile, is there any way that using clean tweezers could change the biological information in the blood?
No.
And why is that?
Well, it's actually, we've touched on it off and on before in that the only thing that's going to happen to a blood stain is through degradation. You're going to get no result as opposed to a changing of the type or the addition if the tweezers happen to be not as clean as you think or have become contaminated in some way. You're going to have the addition of information to it rather than the changing of the existing type that's there.
And if you were collecting a series of stains using one of these improper techniques, or the improper technique of not changing gloves and using the glove itself to collect the stain as opposed to the instrument, would you expect it to somehow change the biological information in all of the stains consistently?
I'm not sure I
In other words,
understand the question.
if you had 5 stains at a crime scene, would you expect the same changes to occur to all 5 stains?
If your gloves are dirty to the point where you are adding information to it and continuously doing this, then you're going to see, if I understand the question right, you will then see this additional or contaminant showing up in all of the samples. Potentially, if you start off with a contaminant from your first sample and don't recontaminate it, so to speak, eventually you would use it up, and I guess your last sample may not show as much, but I don't know.
Okay. When you say contaminant, what do you mean by that?
Well, contaminant is really anything that doesn't belong in its original situation. Example being a blood stain that is left at the scene of a crime is a contaminant to that scene. Anything that's added to that blood after the fact is a contaminant to that blood. It's something that doesn't belong.
So is there any more precise definition of contaminant that's used in the forensic science community to discuss when information is being added to a stain or to a piece of biological evidence that didn't originate in that evidence?
As far as, I mean, a contaminant is what I described before. I'm not aware of any particular definitions when it comes to biological evidence. It's just the addition of something that didn't belong there to begin with.
So it's a fairly ambiguous term, somewhat ambiguous.
I don't know if it's ambiguous so much as there is not a forensic definition of contamination versus, any other definition of contamination.
So using the definition that you gave, could you consider the blood drops themselves of a suspect deposited at a crime scene as being a contaminant?
There would be a contaminant to that location, right?
Now, as to the collection techniques that were used in this particular case, did you view a videotape of Andrea Mazzola demonstrating the collection process of a stain?
Yes, I did.
And did you see any problems that arose in the collection of the mock items in that case?
Objection made.
That could affect the collection?
I didn't see anything in the way that she handled the swatches, the tweezers, that type of thing that would affect the ultimate integrity of the evidence.
I want to show you that video, but apparently they don't have it right here. Let me ask you a few more questions about collecting biological evidence. Is biological evidence, can it be deposited both through direct and indirect forms?
Yes.
And what is the distinction?
So if I understand the question, a direct deposit would be if I cut myself and then proceed to drip it, excuse me, at a scene or a location. A indirect, was that the other?
Yeah.
I believe an indirect or potentially secondary transfer of that evidence or stain would be if I was to drip some of my blood onto a piece of cloth or something like that, then that piece of cloth came in contact with something else, thus transferring it a second time.
And do you as a serologist type both kinds of evidence that was deposited as a result of a direct transfer as opposed to indirect transfer?
Yes.
If you had a situation where a suspect leaving a crime scene stepped in a pool of blood and then went into a vehicle and transferred that blood into the vehicle, would that be direct transfer or indirect transfer?
By the definition given earlier, I'd call it indirect.
And does your laboratory type that kind of a stain?
Yes.
Now, if you view the suspect's action as a collection procedure, in terms of collecting the evidence in the pool of blood from the crime scene, would that be a forensically accepted collection technique?
No, it would not be acceptable to collect a blood stain on the bottom of a shoe.
So why is it that in cases where evidence is collected on the bottom of a shoe, you can still go ahead and test it?
Well, the blood is still the blood. I mean, it's a situation where regardless of whether it was dropped directly from a person or transferred from one to another, it still has some significance. You're aware of the fact that it was not dripped there, particularly when you see a smear or something along that line, but there's still information that can be derived from that sample as far as the genetic types that are present.
Does the fact that the evidence is collected on the bottom of a shoe change the genetic markers in the evidence?
No, it doesn't.
So can it change the blood from the victim's blood into someone else's blood?
No, it doesn't.
Let me give you another hypothetical situation. Let's say you had a situation at a crime scene where a cat walked into the crime scene and collected some of the blood by stepping in it with its paw. Could you collect the evidence off the cat's paw and still test that?
Yes, we could. I'd want a control collected from a clean paw to see if the cat contributed anything to it, but you could test it.
Okay. So if evidence at a crime scene could be collected by a house cat, do you think that the criminalists, Andrea Mazzola and Dennis Fung, were qualified to collect the evidence in this case? Is silly an objection? I didn't know it.
Why don't you rephrase the question?
That's okay. I'll withdraw that question. I'd like to show you the video that's been marked as 1117 for identification.
Noting that we have seen this several times, Mr. Goldberg.
I know, Your Honor, but I'm not going to stop it. We'll just run it all the way through. Mr. Matheson, did you notice that she did touch the ground with her right hand, gloved hand?
Yes, I did.
Does that present a problem?
No.
Why not?
I would be concerned if her hand touched the ground and then she took with the glove on and then she took her gloved finger or something and smeared it around in the blood stain. But with the process of using the forceps or the tweezers, the glove never comes in contact with the evidence itself.
And now she is laying down the control by card number 5?
Yes.
Assuming, sir, that the water in this control eventually migrated over to the stain, would that present a problem?
No.
Why?
Well, the water is the exact same water that is being used to dampen the control swatch and dampen eventually the swatch that you use to collect the blood stain. And the fact that, as you notice, she takes her control very close to the stain, so the substrate or the concrete that it's sitting on is going to be, basically the same under the stain as is under the control. The worst it's going to do is maybe slightly dilute the blood stain, and it may actually start moistening it up, making it easier to collect. That's not a problem.
Would it change the result in any way, the migration of the water?
No, it would not.
Now, if you look closely, it appears that some swatches fell out of the cap.
Yes.
Does that present a problem?
No.
Why not?
Well, I don't believe that at any point does she take any of those swatches and use them to collect any of the sample. They're left sitting down there. Actually, they're brushed aside at some point. You're going to drop them occasionally. That's just the nature of it. There's a lot of swatches in that vial. You shake them out, a few are going to fall on the ground. I suppose it could be a minor littering problem if they didn't pick them up when they were done, but as far as the evidence goes, no, it doesn't affect it.
Now she's collecting the stain from the item that was labeled number 5 in this demonstration.
That's correct.
Now she appears to be putting stain 5 into one of the plastic bags.
Yes.
Are those the kinds of plastic bags that you use at the crime lab when you're collecting stains?
Yes, it is.
Now we've gotten up to the point where she's already collected the control and the stain from card number 5.
Yes.
Have you seen anything up to this point that would cause the results that you obtained to change into someone else's blood?
No, I have not.
Or that would present a problem in terms of the analysis of the blood?
No.
Has her collection procedure been in accordance with the way that you're training people at the crime laboratory to collect evidence?
Yes, it is.
Now, Mr. Matheson, she appears to be working on the second stain at this time.
That's correct.
And is there any problem with not changing tweezers or gloves between stain 5 and stain 6?
No, there isn't.
And why is that?
Well, as I mentioned earlier about the gloves are not coming into direct contact with the evidence. That's not a problem. If you'll notice, she has cleaned the tweezers several times between each of the steps using dampening, that Kim wipe that I mentioned before, the tissue with what appears to be water, and then wiping the tips of the tweezers or forceps off very carefully.
And is this collected in such a way so that the swatch itself does not come into contact with the gloved hands of the criminalist?
That's correct.
Now, she appears to just have written something on the plastic bag. What do you write on the plastic bag when you're collecting a stain?
Actually, it depends. Obviously, within one envelope, eventually, when you're collecting a stain off of something like concrete or off of a surface, you're going to end up with a coin envelope or the manila envelope containing 2 separate plastic bags with the samples in it. Usually, I like to mark either the item number on it, or if I don't do that, at least a C on the control plastic bag. However, there have been times where it was very obvious which was my control and which was the stain. The stain was blood colored and very heavy, and the control was either relatively clean or kind of a grayish, so it didn't matter whether I marked them or not because it was obvious which was which.
Now, just before this, she dropped a few more swatches. Again, did that present any problem in terms of the collection of stain 6?
No.
She's just placed the swatch of number 6, the blood swatch, into the envelope.
That's correct.
Have you seen any problems in the collection procedure to this point?
No problems with the collection procedure. The only thing that I would, if this was a training issue or something for us, or we were looking at it, I would suggest that maybe it'd be worth going back with another swatch on the evidence sample and collecting up a little bit more blood.
Okay.
But as far as the collection technique itself, it's just fine.
So if it were a real stain, you'd want to use more swatches on both 5 and 6?
Yes, yeah, to get as much of the sample as possible.
All right, thank you. And why is it that you use multiple swatches on a single stain?
Well, we teach the people to select a swatch size that's appropriate for a stain. If you have an extremely small drip, you don't want to use a real large swatch because then the blood stain gets kind of diluted out over the swatch itself. If you have a large stain, theoretically, she could have gone with a larger swatch on that than she had that she'd chosen, but odds are that was among the largest one that was in that vial. So instead of going to a much larger one that isn't available, just use multiple smaller ones.
Is that typical that multiple swatches are used in collecting a stain?
Yes.
And when multiple swatches are used, is the criminalist supposed to notate how many swatches they used at the crime scene?
There's no rule to that effect, no.
Okay. Why is it that you don't have a rule in place that you should notate exactly how many swatches you used on a particular stain?
Because we've never found it to be important to know exactly how much is there. You've got your photograph of the stain, the evidence is the stain that's down there, and the swatches are immediate to collect it on.
Okay. Now, let's say that someone at a crime scene, a police officer who didn't know how to collect a stain, had used a completely improper technique, such as taking out a handkerchief and spitting on it to dampen it, and then collected the stain using that technique, submitted it to you for analysis. Would it still be possible to type even in that extreme situation?
Yes, you could still do an analysis on that stain.
Wouldn't the police officer have arguably introduced some contaminant that could be tested as a result of spitting in the handkerchief?
Definitely, it'd be an improper way to do it, but it could still be typed.
So what would you do in order to resolve that problem?
Well, in a situation like that, if that was the only evidence that we had available to us, we would be able to run the particular stain. I would want to run a control area from the Kleenex and also get some saliva from the particular officer.
Well, what could you do if you had some saliva from the particular officer in order to sort out what the genetic markers were in the person who deposited the stain?
Well, if you had saliva from the person and that particular marker appeared in the saliva, you'd know the type of the individual who spit onto the handkerchief. How that affects your ultimate interpretation will depend an awful lot on the types that were found in the stain and the types in the person. It obviously is going to lessen some of the value of that stain, but there's still information there.
Could you still determine whether the genetic markers of the stain were consistent with the suspect, even though this collection procedure had been used?
It's possible. It would depend on the types of the people and how the results came out, but it's possible.
Okay. But would the spitting in it actually cause the genetic markers of the suspect in the stain of blood to somehow change, or would they still be there?
No, they'd still be there. You'd just be introducing additional information to it in the form of the types of the person with the saliva.
And does the Los Angeles Police Department serology section, in fact, type cases routinely where there are mixtures, where there's more than one donor to a particular stain or a particular item of biological evidence?
Yes. Every sexual assault case we do, by nature, if there's semen present on a sexual assault kit that's collected from a victim, you are dealing with a mixture of body fluids.
And in those kinds of cases, are you still able to test that mixture to determine whether it contains genetic markers that are consistent with the suspect?
We're able to do the tests. However, because of the fact that it's a mixture, our chances of giving a very definitive answer as to what's coming from the victim and what's coming from the suspect is less than when you're dealing with just a blood stain. But there is still information to be derived.
And are there still instances where you're able to find that there are certain markers that are consistent with the suspect, but inconsistent with the victim?
Yes, we do on occasion include suspects based on what we find that's foreign to the victim and could have come from that suspect.
So in these sexual assault type cases, do you usually get evidence of a mixture from two people?
Many times, yes.
And then if you get a mixture from two people, what do you have to do in order to figure out which part of the mixture belongs to the suspect and which part of the mixture belongs to the victim?
I'm going to object to this line of question. It's irrelevant as to the blood stain.
Close. I think this is just a, let's wind this up.
Okay, I'll withdraw that question then.
All right.
Now, sir, if bloodstains can be collected by people who are not criminalists, why does the Los Angeles Police Department use criminalists or try to use criminalists in collecting these stains?
Well, a criminalist is not just performing the function of collecting a stain. What we have in our laboratory is what's called a generalist philosophy, where we try and teach a criminalist about all aspects of forensic science. They may specialize in one particular area like toxicology or firearms or serology, but through experience and involvement with other criminalists, we try and get them to have a sense of the whole concept of forensics. So by having somebody out there at the scene that works in the laboratory and is acquainted with all the different possibilities that exist, when it comes to analyzing physical evidence, it just enhances the possibility of collecting the best possible evidence.
Now, at crime scenes, does the police department use both criminalist 1s and criminalist 2s and 3s for the purposes of investigating a crime scene?
We send all those out. As a matter of fact, we send out at times supervisors and lab directors go also.
And when you send a criminalist 1 to a crime scene, are they paired with someone?
Yes, as long as they're a criminalist 1, which is for the first 18 months of their employment, they will always go with either a crim 2 or a crim 3, preferably a criminalist 3.
What is the purpose of sending the criminalist 1 with the criminalist 3?
Well, it's all part of the learning process. We're always learning new things when we're out there, and for that first 18 months or so, we try and get them out as many scenes as possible, exposed to a lot of different conditions and types of scenes, to the variety of techniques that different criminalists have as they go through their career, and allow them to then establish their own, mindset or experience to collecting evidence, so that when time comes that they are doing one on their own or potentially training somebody else, they have all the experience that is afforded to them.
So what is it that the criminalist 1 is learning in this first 18 months? Are they learning the physical mechanics of how to pick up evidence? Or are they learning the mental processes that a criminalist goes through?
Well, they're learning both. It depends on the background of the individual. If we have somebody start in the laboratory that has some sort of forensic background or experience, odds are they've picked up the mechanics. We're going to confirm that the first, couple of times they go out. But, they're not difficult techniques. After that, it's a matter of just getting exposed to an awful lot of different ways of looking at a scene, the way of thinking about how to go about processing it, and just constantly picking up experience. I still go on crime scenes myself where I learn something from somebody else on either a better way to do it or, thinking about something that I hadn't thought of.
So after the criminalist 1 already knows the mechanical techniques of how to pick up, say, biological evidence and shoe prints, lifts, and the like, why is it that you just don't set them loose and let them go to the crime scenes themselves for the remainder of their probationary period?
Well, it's kind of like we were talking about before. we want them to get as much experience as possible when it comes to how to evaluate a scene. We can teach anybody to go out there and do some of the mechanics, but there's this buffer, this 18 months from the time somebody starts until they are considered crime scene ready, or that's a target that we shoot for, where you are learning. You're just, like I say, being exposed to new situations, new things, taking in as much information as you can about the mindset of investigating a crime scene.
When you say mindset of investigating a crime scene, what are you talking about?
The different philosophies of what type of evidence exists, how to approach the evidence, how to think through and use selectivity that we were talking about earlier as far as trying to find the evidence that's most important to the questions at hand.
Which part of being a criminalist, in your experience, in terms of investigating crime scenes, is more difficult? The mechanical part of how to pick up a piece of evidence, or the mental component of what type of evidence to pick up?
Well, it's definitely the mental component because, like I just said, I've been doing it for almost 17 years, and I'm still learning stuff out there. I go out to a crime scene and almost always get a little more insight in how to handle a scene.
Now, when the criminalist is at the crime scene, do they have an obligation to investigate whether there have been any alterations in the crime scene?
Their primary function there is the collection of the evidence. The information as to whether or not something has been altered is really not very deep. We sometimes record if like a rescue unit had been in prior and dealt with the scene or something along that line. But normally we have our hands pretty full just looking for the evidence and collecting it, documenting and collecting it, so that when it comes to searching down every little bit of information as to whether something was touched or something was moved, no, that's not our duty.
Here we can see Defense 1081. This is this a portion of the crime scene identification checklist form?
Yes, it is.
And here there's a little section that says, has the scene been altered? If so, by whom and how? How is that portion of the checklist supposed to be used?
I have always used it and taught other people to use it, that it is for gross information. Like I just mentioned, if the rescue unit had arrived prior to our being there, because they many times leave things behind that we don't want to collect as evidence if it was brought in after the fact. Such things as if an area was washed down prior to our arrival, which does happen sometimes. More of that gross type of information.
And is the criminalist ever supposed to do formal witness interviews of people to determine whether the scene's been altered so that this area can be filled out?
No, they're not.
Now, what about crime scene security? What does the criminalist have to do with providing for security or seeing that security is provided for at the crime scene?
Our major concern when it comes to crime scene security is just like wearing gloves or other protective equipment. I want to make sure that the scene is secure for my own safety and protection. I'm going to arrive, I'm going to make sure that there are officers at the scene or detectives or somebody else that's present. The fact that we're a civilian, that's important. As far as making sure that there is tape up or officers present to keep out people that may alter the scene, it's not our responsibility to do that. There have been instances where I have been working a scene and somebody has walked through the tape and is like heading into the crime scene or something, and I will see it before the officer and I'll point it out and say, hey, we need to get this person out of here. But that is not my prime focus. My prime focus is in on the evidence and the evidence collection.
Now, at a crime scene, is it typical that photographs are taken both before the body is removed and then after the body is removed?
Normally, yes.
Why is that done?
Well, to properly process a crime scene, you want the photographer in there as early as possible before, obviously there are certain things that must occur. If you have a victim, there's going to be an initial responding officer, somebody going in to clear the scene or whatever. That's prior to our arrival. But as far as processing a scene, we want a photographer to go in even before the criminalist to document everything exactly how it is before we get in there and start, moving things around or taking measurements or walking through the scene. We then have after the overalls or the general shots are taken, have our individual evidence items photographed, and that could be happening either before or after the body's present.
How often is it that a piece of evidence is moved between the before photographs and the after photographs?
It happens occasionally.
And in what context does it happen?
Well, there are times where a particular piece of evidence may have some information on it that is needed at the moment, a piece of paper with some writing on it, an item that we want checked for blood or something like that. If the photographer isn't available, there will be times, knowing that the overalls were taken, knowing that the general scene has been placed with photography, we may pick that item up, run a presumptive test on it, or, like I said, look at a piece of paper for some writing or something, and then try and place it back for the close-up picture just prior to collection. Sometimes it's not going to be placed back in the exact same location. And it does occasionally happen, too, that during the course of your processing, you may accidentally bump something or you may kick it. You try real hard to watch for your stepping, but sometimes you do get focused on other things that you're doing, and evidence does get moved. That's one reason why it's so important to get the photographer in there first, because those are the pictures that place the evidence items where they belong or where they were originally. And then the subsequent photography is mainly to identify that item, to get good close-up pictures of it, so at a later time you can compare it to what you have in front of you.
So part of the reason for taking the before photographs is so that if an item of evidence is moved, you can determine exactly where it was initially?
That's correct.
Now, in the testimony that you heard, did you hear some evidence as to a phenolphthalein test being performed on the glove at the Rockingham location?
Yes, I did.
And is that acceptable from a forensic standpoint and from a crime scene investigation standpoint?
You mean as far as running a presumptive test in the field?
Yes.
It is, however, it depends on the particular item. If there was a evidence item or a extremely small spot of blood or a extremely small stain that you thought might be blood, and that by running your presumptive test was going to consume either all or a major portion of that stain, I would not want the criminalist to run it. I wouldn't run it myself. I would just collect it, where you can then do that same test in the laboratory, but on a much more micro scale. However, many times in the field, we do test objects and bloodstains for the presence of blood. And if you have a large stain, you can see a area that's discolored. In this case, the glove that was showing, because it was a black glove, you didn't necessarily see what was obviously red blood on it.
I'm going to object to the error response.
We are. We've gone beyond the original question. Proceed.
Sir, would you have done a phenolphthalein test had you been asked by one of the officers there to perform one in the field?
Object, cause for special purpose.
Sustain.
In this particular case, based upon your understanding of the evidence, would doing a phenolphthalein test harm or somehow interfere with the ability to do future testing on that glove?
Objection, Vegas, in this particular case.
Oh, well, I take it we're talking about the,
Phenolphthalein.
which glove?
Talking about the Rockingham glove.
All right.
The only thing it would do would be to remove a small amount of the blood that was present. It would not alter the type in any.
Do the criminalists comply with reasonable requests that are asked of them at the officers at the scene?
Yes, they do.
Objection,
Overruled.
And would it be reasonable, in your estimation, under the facts and circumstances of this case as you know them, to have requested a criminalist to do a phenolphthalein test on the Rockingham glove?
Objection.
It's vague. Or, reasonable in a scientific sense? Is that what we're interested in?
In a scientific sense, from a forensic science standpoint.
Do you understand the question?
Yes. Yes, I believe it would be reasonable.
Generally speaking, at a crime scene, how do criminalists interact with the detective?
Objection for rebuttal.
It's vague.
What is the relationship in terms of the collection of the evidence between the detective and the criminalist?
As far as the collection of the evidence, that's the domain of the criminalist. Normally, when we arrive, the detectives have already been there. They do the walkthrough with us. We interact with them, get their opinion as to what they have found, what evidence they are interested in collecting, and we note those items either mentally or on paper, depending on the person, and do a search ourselves. So we try and interact with them, working as a team regarding that aspect of the crime, and that is the scene and the collection of physical evidence.
Now, did you also hear some testimony about a blanket that was at one point brought out for the purposes of covering Nicole Brown?
Yes, I did.
And what kind of problem would that blanket present, if any, in terms of the biological evidence at the Bundy location?
Objection. No foundation.
Sustained.
Sir, if a blanket were brought out into a crime scene, are you familiar with the layout of the crime scene?
Yes, I am.
Into the area where the body of Nicole Brown had been laying for the purposes of covering her, and then the blanket remained there after she was removed. Would that present a problem in terms of the biological evidence that was collected from the Bundy location?
Objection. Vague. No foundation.
I'll sustain the vague. The question's unintelligible.
Would that present a problem in terms of contaminating any of the biological evidence?
It would depend on what the blanket had on it to begin with. If the blanket had large quantities of blood or had blood on it, and then that blood came into contact with something that we eventually ended up collecting, then we would have contamination occurring at that point. If it was a clean blanket, as far as the biological evidence is concerned, and it does not come in contact with the collected evidence item, it should have no effect.
Okay, well, let's assume hypothetically that the blanket had some saliva from the defendant in this case on it that had dried and did not come into contact with the stains that were collected along the trail. Would the blanket present a problem in terms of contaminating those stains?
No, it would not.
What would you have to do in order for the blanket to contaminate the stains?
The biological stain on the blanket would have to somehow come into direct contact with the biological sample that was being collected. And even then, unless there was some moisture present, you would not have significant transfer. If one or both of them was damp and they came in direct contact with each other, then that would be a problem. You would have potential transfer of one body fluid into the other, thus contaminating it. But beyond that, it should not have a problem.
So even in the case of direct contact, you're saying that the biological material on the blanket would probably have to be wet in order for there to be a transfer?
For there to be significant transfer yet, I would not like to see that happen, and I would be concerned about any sample that happened to. But the transfer would be significantly less than if one or both were damp.
Okay. And if it did not come into direct contact, then you're saying that if we were to assume that the only biological evidence were the hypothetical dried saliva, it would not present a problem?
That's correct.
Now, DNA tend to fly around in the air at a crime scene and deposit itself wherever it happens to land?
Just randomly floating around a scene?
Yeah.
No, I wouldn't expect that to happen.
And if you have a crime scene where biological evidence has been deposited by a suspect who was bleeding on a trail of stains, do you expect biological evidence from one stain to migrate to the other stain? If we assume that these are discrete drops.
I don't see any way that if they're discrete drops, how you'd get one transferring to the other unless there was something carrying it from one to the other.
But it doesn't just like hopscotch from one stain to another in some fashion.
No.
Now, did you also hear some evidence to the effect that the glove from the Rockingham location was in a brown paper bag and was brought into the caged-off area where the body of Ron Goldman was located?
Yes, I have.
And what problem, if any, does that present in terms of contaminating the crime scene?
Well, merely bringing an item in a paper bag should have no effect whatsoever on the evidence at that location.
What about on the glove?
You mean evidence from the scene getting onto the glove?
Yes.
The same thing. It's inside of a paper bag. It's not coming in direct contact with any of the evidence at the scene. I don't see where it would be a problem.
Now, there was also some evidence of some socks being recovered at the Rockingham location. Are you generally familiar with that?
Yes, I am.
And you took a look at those socks yourself?
That's correct, a couple times.
Now, would you expect there to have been flaking from blood encrusted on those socks at the time that they were taken off based upon what you saw?
Objection.
Sustained.
Did you do an analysis on the socks yourself?
Yes, I did.
All right. And were you familiar with the extent to which blood was visible on the socks from the naked eye?
Yes, that's correct.
Now, was there sufficient quantity of blood that you would expect flaking off the socks at the time that they were taking off?
I'm going to object to that any further time.
Sustained. Expertise.
Okay. Under what conditions, sir, will blood flake off of clothing, if you know?
Well, if you have, it kind of depends on the quantity. If you have let me take a step back again on that. By flaking off, I mean, you are going to have the potential of very small, minute quantities of blood falling off, which could be called flaking. Or if you have a very heavily stained item that has crusts of blood on it, then flaking could be visible chunks of the blood falling off.
Well, when you saw the socks, were there any visible chunks of blood of the kind that you just described that might fall off?
Objection to that foundation.
Sustained.
When did you see the socks, sir?
The first time I saw the socks was on June 29th, 1994.
Okay, and what did they have that kind of blood that was in sufficient chunks that you would expect it to flake off at that time?
No, they did not.
Now, when an item such as the socks is collected in the field, is the criminal supposed to do a close physical examination of it prior to collection?
There's no rule that says that they have to do a close examination of any of the items they collect at the scene.
Would there be any reason to?
None other than maybe personal curiosity. If you have an item that you are collecting anyway, there would be no particular good reason to do a very minute examination of that item at the scene.
After you've already made a decision to collect the item, is there any reason from a forensic standpoint to inspect it any further in the scene?
Not in general. If there was some particular piece of information somebody was interested in deriving from them, maybe it would require a closer look. But once it's been decided to collect them, you're going to do that back at the laboratory.
Now, in terms of the removal of the bodies from the Bundy location, do you feel that a decision should have been made to wait until the criminalists had the opportunity to look at the area where the bodies were removed before they were removed?
Yes.
And how do you go about making that decision as to whether to allow the coroner in first or the criminalist in first?
Well, normally, we like to get in and do our search, get our overall photos, do our search, and collect at least all the evidence right around the body or bodies prior to the coroner's arrival. Our concern is the total scene where theirs is the victim. And we like to get done as much as our work as possible so as to limit the amount of activity in and out around that evidence until it's collected.
So how are you balancing the need for them to do their work against the need for you to do your work?
Well, I'm looking at it from my perspective. From my perspective, the information that we get and the evidence that's surrounding the area is just as important or more so than what they may derive from the bodies at the scene. And I'm going to be protective of that and want to get my work done first before there's any chance of any sort of disruption or contamination caused by, there's a lot of handling involved when the coroner's office arrives.
So from your perspective, would it have been desirable to have waited even longer before allowing the coroner's people to have access to the bodies?
From my perspective, yes.
Now, we've had a lot of discussion about what Andrea Mazzola's exact job description and title is. Can you tell us what her title is?
She's a criminalist 1.
And is there such a category as a criminalist trainee?
No, there is not.
Do you use that term officially to designate criminalist 1?
No, we do not.
And also there was a description of a mini academy. Are you familiar with that term?
The first time I heard mini academy was in this court. There is an SID academy, yes.
So you just refer to it as the academy?
Well, we refer to it as SID academy. It's a simple way of talking about training courses we have for new people.
Okay, but in terms of an academy, it's not a thing where you sleep in a dormitory style housing for a period of time, is it?
No, it's much more informal than that.
And at the mini academy, are the criminalists trained in how to do the physical collection techniques at a crime scene?
That's one of the things that are discussed.
And what other kinds of things come up at that mini academy, just in general? I'm sorry, academy.
Part of that set of training courses is to acquaint new people with what criminalistics is all about. The people that we hire many times are not fully acquainted with forensics, do not have prior forensic experience. So part of that process is teaching them what the other units are about, giving them an overall concept of what criminalistics is.
When you say that they all are not acquainted with criminalistics or forensics, does that mean that you're hiring some people that don't have degrees in criminalistics?
That's correct.
So what are their degrees in?
Well, the requirement for the position is a baccalaureate degree in a natural science. And we have many people that have degrees in chemistry, biology, biochemistry. I believe we have one in zoology, one in oceanography. We want people we require that people have a degree in a science so that they've learned, basic scientific principles, the scientific method, and that type of thing. And then we train them within the laboratory about forensics.
Were you aware that Andrea Mazzolo did have a degree in criminalistics?
Yes, I was.
And on the 13th of June, were you aware that Andrea Mazzolo and Dennis Fung were processing the crime scenes at the Rockingham and Bundy locations?
Yes, I was.
Is it generally desirable to have more than 2 criminalists handling a given case in terms of collecting the evidence on a single day?
Haven't we covered this already?
Not with this witness.
We talked about having teams and the advantages and listing
But
documents.
more than 2. I haven't discussed that.
All right.
That's an issue that came up. I'll be very brief, and then I'm moving on to another area you're at.
We'll be brief, and then we're going to take a break.
Thank you.
2 is actually a fairly optimal number. I have done many scenes by myself, and I feel that is not the best way to do it. I've done many scenes with 2 people, and that is great because you've got somebody working with you. You can bounce ideas off of each other, get assistance when it comes to taking notes, collecting the items. You actually do it quicker and I think better with 2. When you get past that into 3 and even 4, which would be excessive, you just have too many people in the scene. Many times the scenes of the crime that we go out to, the location of them is very limited, and you just start getting too many bodies in there, you start bumping into each other, and it's not as easy. So 2 is probably the best number to handle as a crime search team.
Thank you. Your Honor, I was now going to get into another area.
Ladies and gentlemen, I'm going to take a recess at this point for 15 minutes. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, don't allow anybody to communicate with you, do not conduct any deliberations until the matter has been submitted to you. Mr. Matheson, you can step down. Your return in 15 minutes. We'll stand in recess for 15. Mr. Byrne, my research attorney, gave each party a photocopy of the handwritten 11-page list of evidence items in this matter. I did have Mrs. Robertson get the exhibits from the August Griffin hearing and August 94 Griffin hearing, and it does include a copy of this as item K. So the defense did mark that they did have access to it at that early time, so the record should be clear. And Mr. Blazer, you have a copy of that now before you?
I do, Your Honor.
All right. Do you feel you need any additional time before we move into this item?
No.
All right. As to the second item, the board the prosecution proposes to use regarding the defense testing of evidence items or taking those matters out of the prosecution's custody for their testing purposes, I'm going to ask the prosecution not to use that board this afternoon because I'm not comfortable with the state of my research at this point. All right, let's proceed.
Your Honor, there was
Yes.
one other issue that I wanted to bring up, and that was I wanted to make, I guess, what would be a 402 type motion as to what extent Mr. Matheson will be allowed to discuss the issues of PCR typing and PCR type issues, which he is not testifying to in direct, except only extremely tangentially to the extent that evidence collection has some overlap to the issue of how a sample can be contaminated, but subsequently going to be tested both conventionally and genetically. Specifically, there was an issue regarding some a lot, not a lot in number, but a lot as in a discrete, identifiable number of test kits that were provided to the Los Angeles Police Department by Roche Pharmaceutical some time before this case. I believe it was many months, in which there was a problem that was identified with the kits that I'm sure counsel probably intends to get into with perhaps other witnesses. But Mr. Matheson does not have any personal knowledge of that, nor has he read any documents, to my understanding, pertaining to that. So we would ask that they be precluded from getting into that area on cross-examination of the witness.
Well, having not heard anything about it yet, I'm loath to make any kind of a ruling on a basis that this is prematurely brought before the court.
Well,
If it exceeds the scope of the direct examination,
I'm sure the defense will come up with some reason that it's within the scope or necessary to cross-examine Mr. Matheson about it. I don't know.
I haven't heard it yet, so.
Your Honor, there's been plenty of questions about contamination, and that's directly on point in terms of contamination for later DNA testing, so I think it's already been raised.
Perhaps, but within the specifics of this witness's knowledge regarding PCR testing and the exquisitely sensitive nature of that test, I don't know if he has the expertise to testify to that.
He's in charge of the lab.
I don't know.
Okay.
We'll see. We'll see. It's not here yet, guys. All right? Let's have the jurors. Let the record reflect we've been rejoined by all the members of our jury panel. Mr. Gregory Matheson is again on the witness stand undergoing direct examination by Mr. Goldberg. Good afternoon again, Mr. Matheson.
Good afternoon.
You were reminded, sir, you are still under oath, and Mr. Goldberg, you may continue with your direct examination.
Good afternoon, ladies and gentlemen. Mr. Matheson, I wanted to ask you some questions about the Scientific Investigations Division facility. Where is that located?
It's located in a city building called the Sierra and Piper Technical Building, or Piper Tech for short.
Okay. Your Honor, at this time I'd like to mark as people's next in order 206 for identification, which is a board that contains photographs and a map of the SID facility.
All right, People's 206. All right, Mr. Bancroft, I'm going to need you to help me with this. All right, proceed.
Sir, can I pay attention to People's 206 for identification? Do you recognize this exhibit and the photographs on it?
Yes, I do.
Is there any sort of accreditation agency that covers crime laboratories in the United States?
Yes, there is.
And is that a public entity or a private entity, or?
Well, it's a association made up of crime laboratories that have been accredited. It's called the ASCLD, or American Society of Crime Laboratory Directors Laboratory.
But I mean, is that a governmental agency, or is it a private agency outside the government?
Well, it's not, my understanding is it's not a agency in and of itself. Most of the members of it are accredited laboratories, which are government.
Is it mandatory under state or federal law that you have that accreditation from this organization?
No, it is not. It's a voluntary process.
Does it cost money to become accredited?
Yes, it does.
How much?
Depends on the laboratory. The cost is associated with, it's actually associated with a couple of things. One of them is if there are any sort of facility changes or something, obviously the agency has to come up with the money to meet the accreditation standards, but just to apply, there is a fee associated with the inspection process. And my understanding is for an agency of our size, it could be anywhere from, say, $10,000 to $30,000.
So you would have to pay $10,000 to $30,000 to get this accreditation?
Yes.
And does it allow you to do anything that you can't do now?
No, it's just a review by this outside agency of whether or not we meet the standards that they've established.
Has the city come up with the $10,000 to $30,000 for you to be able to buy this accreditation?
Well, it's not a matter of buying the accreditation. It's paying for an inspection to see whether or not you pass. No, to this date, we have not received the funding to do that.
Now, turning your attention to this map that's 206 for identification, does this depict the Piper Tech portion of the SID, Scientific Investigations Division? The map.
Yes, the map itself covers the area that's part of SID at Piper Tech, yes.
And are there facilities that SID has that are outside of Piper Tech?
Yes, there is.
And are there photographs of the facilities that are outside of Piper Tech over here, if you look in the upper left-hand corner?
Yes, there's actually two photographs that depict part of our laboratory that's located inside of the Police Administrative Building or Parker Center.
That was where the old Dragnet series was filmed.
That's correct. At least it looks like that, yes.
Okay. Now, what is done, if you know, in the facility that's located at Parker Center?
The suite of 3 or 4 rooms that we have over there are part of our PCR laboratory.
And PCR is?
It's a technique used to identify DNA markers that are present in body fluids.
Now, you said that
biological samples.
you said that you did conventional testing on some of the evidence in this case.
That's correct.
And what facility did that take place in?
That testing all occurred in Piper Tech in the serology unit.
So that would represent, when we're talking about Piper Tech, the area that's depicted on the SID Piper Tech map on this exhibit 206.
That's correct.
Now, how old is the Los Angeles Police Department Scientific Investigations Division?
What about the crime laboratory has been in existence since 1923, I believe.
Was it the first crime laboratory that was set up in the country, to your knowledge?
Yes.
Even before the FBI?
Yes.
And how old is this physical plant?
I believe we moved here in February of 1990, I think, or 91. 90.
Okay. Now, do you have certain security procedures that are in place in terms of the physical plant located at the Piper Tech facility?
Yes, we do.
And who's in charge of that?
I'm the security manager of that facility.
All right. And specifically, do you have a card key system to get in and out of the facility?
Yes, we have. It's an electronic tracking system that you have to use a electronic card. It reads your card, determines whether or not you have access to a particular door at that time of day and that day of the week. If you do, then it unlocks the door for you and allows you to enter the facility or into the individual labs at that point. If you don't, the door remains locked.
And we can see the photograph up on the Elmo that says card key entry. No. Can that be turned around?
I think we're upside down there. All right, Mr. Matheson, why don't you grab the pointer that's right there?
Well, I see it's a little lopsided as oriented up here on the Elmo, but why don't you just tell us using the photograph that's actually on the hard copy, 206, what's depicted in that photograph?
What we have here is a photograph that shows this is a door frame alongside here, somebody's hand that's holding one of our access cards in it, and there's an antenna inside of the wall. If you hold your card up in the vicinity of that antenna, it reads your card, reads the code that's on the card, checks the computer to determine whether or not you have access to that door that time of day, that day of the week.
And who has access to the crime laboratory?
The people that work in the facility, the access levels vary. It depends on whether we're talking about the outside entrance or the interior one or the variety of different labs. It's limited to the people that work in the facility or the other members of our crime laboratory that happen to work in some of the outside locations.
Okay, well, let's start with just if you want to get into the portion of the facility. Maybe we can see the outside of the crime lab photograph. It says SID Piper Tech. We had it up there a little while ago. Okay. Is this the outside of the facility?
Yes, it's the outside wall of the laboratory, which is within the larger building called Piper Tech.
Okay, now do you need a card key entry to get through this door?
Not during normal working hours, which are Monday through Friday, from the morning until the evening. On weekends and at nights and in the very early morning, that door remains locked, and the only way you can get in is by having one of the card keys and having access to the facility at that time.
So who has the authority through these card keys to get into the facility, either in the evening or off hours?
Well, we do have some light-duty police officers that work as couriers. They work in the AM hours, so they have access on getting in there. All of the criminalists can enter in the facility during through this outside door any time of the day and night. And we also have the opportunity to make temporary changes, like sometimes our administrative staff or our support staff needs to get in to do some work on a weekend or something like that. And we'll do a temporary change on their access so they can get into to work.
And does the call-out line from that photograph indicate where this facade is located, the tiles?
Yeah, this particular wall is along this area here on the near where it says entrance. That's that door.
Okay. Now, after you get into the entrance, if you can see the area that says lobby,
Yes, right in this area here.
can we see that photograph? Okay, then there's another door on the right side of the photograph and a window on the left. What is the door?
Okay, the door that's depicted on the right side of the photograph here is the door that actually goes into the hallway area of the laboratory. Like I mentioned before, this outside door unlocks and stays unlocked during what we consider our normal business hours, so anybody can come and go during that door. However, to get actually into the laboratory, you need to, again, show your card to an area so that the antenna can pick up the code, and then it'll allow you in if you have access to it.
And can the couriers go in there?
Yes, they can.
And what about the criminalists?
Yes.
All right. Now, after you're through that door, if we could see the picture that says entry corridor, does that show the view that you have after you've entered through that door?
That's correct. Right after walking through this door, that's your view down the hallway. You're looking down now in this direction.
And the hall's kind of in a square that goes around the facility?
Right, there, the hallway, once you get past here, anybody, once they pass through that door, has access to this hallway area, then back over.
Okay, so when you're saying that door on the diagram, are you pointing to the door that's next to the call-out, or that's just to the left of the call-out line that's adjacent to photograph number 21 that says entry corridor?
That's correct. It's the door that's directly opposite the entrance into the lobby.
And when you said here, there's what appears to be a corridor, and it has various red crosses in it.
That's correct. There's a corridor that runs basically around the not the perimeter, but through the middle of the laboratory. You can walk all the way around without going back to this one point. Yes.
Okay. Now, other than the couriers, do any uniformed police officers have access to the the corridor, the area past in the corridor that you just described?
The only other uniform officers that have a card key that gives them access into the laboratories, we do have one officer that works as a narcotics analyst within the laboratory. That would be at Blessed Couriers.
Does he have a degree in criminalistics?
No, I believe his degree is in chemical engineering.
So he's actually working essentially as a criminalist in one of the laboratories?
That's correct.
So he is the only officer that has access to the corridor area other than the couriers?
That's correct.
And what about detectives?
No, detectives would have to be escorted in or allowed into that corridor area
With a criminalist?
with the criminal or with another personnel that happen to have access to it.
Now, are there any windows in any part of this facility?
Not looking to the outside. The only windows that we have are from some of the laboratories into the hallway.
Now, let's take a look at the evidence processing room up in the upper right-hand corner of the photograph on the left side. What does that depict?
Okay, this picture marked SID EPR, EPR stands for Evidence Processing Room, points to an area in the upper right-hand corner of the map here that's marked Evidence Room. This is the area where, when evidence is collected out in the field, it's brought into this room to be dried and then eventually identified, marked, and stored or prepared for storage.
And there appears to be a roll-up door in this photograph on the right-hand side. What's that?
That's correct. In the right-hand side of the photograph here is a door that rolls up here, or rolls up towards the top, and it is this thinner line to the right of the evidence processing room 29B.
And the call-out line on that photograph depicts where the photograph is showing.
That's correct.
Now, that rollout door, do you have to roll it up by going inside the evidence processing room?
Yes, the only way to roll it up is on the inside of the wall, next to the door between the storeroom and the evidence processing room, is a control button that says, I think, up, down, and stop, or something like that. That's the only way that door can be opened.
And does the door to the evidence processing room itself, I guess it would be the door that is between the storeroom and the evidence processing room, is that also card key controlled?
Yes.
Now, who has access to this room?
The door that exists between the storeroom and the evidence processing room, all criminalists have access to that room 24 hours a day, 7 days a week, so that they can bring evidence in there. Other personnel, such as our lab technician that we have in the laboratory and some of our student workers, have access to that room during normal working hours during the day, Monday through Friday. The support staff, clerical staff do not have access to that area.
So that the support staff do have access to the corridor area, don't they?
Yes, they do.
But they can't get into the evidence processing room through their card keys.
That's correct.
And what are the student workers?
Student worker, that's a position that we have. I believe we currently have 3 of them. They are people that have an interest in forensics or working towards their degree for eventually becoming a criminalist. The positions we currently have for them is we have 1 in toxicology, 1 in our trace unit, and 1 in serology. They assist the criminalists with like preparing some of the chemicals, whatever needs to be done that can free up the criminalist to do casework.
Now, in terms of the evidence processing room, can someone who has a card, well, with respect to any of the card key entry areas, can someone who has a card bring in someone who doesn't?
Yes.
And in the case of police officers, are police officers allowed into the evidence processing room?
Yes,
And if they were allowed in there, would they have to be accompanied by someone?
that's correct.
So they do not have a card to get into that portion of the facility either?
No, they would not be able to get in there without being escorted by somebody.
Other than the one gentleman who's working as a chemist in the toxicology, did you say? Or
In our narcotics.
narcotics? All right. Let's take a look at the evidence control unit now. Okay, this is showing what? ECU lobby, the photograph.
The photograph that's marked ECU lobby, ECU stands for Evidence Control Unit. That is a property storage room that is actually run from within SID. The Los Angeles Police Department has property officers and we have a property division, but SID has our own property room of items that will probably be eventually analyzed, so they're very nearby and under our control. The picture that's depicted in marked ECU lobby is an area that is just off of the laboratory lobby. It's marked lobby on the map here. The only way to get to it is from the outside entrance through the criminalistics lobby and into the ECU lobby.
So when a police officer is coming to the laboratory to pick up evidence for court, where does he or she go?
They go into the ECU lobby. The front door is unlocked, so they can come in there. They pass through the criminalistics lobby into the ECU lobby, and there's a couple of windows where our property officers can interact with them, find out what evidence they need, and then they go back and get them and bring it forward to them.
And is that what they would do if they wanted to check out evidence that needed to be brought to court to be introduced?
Yes.
Now, let's take a look at the inside the ECU. Let's see if we have a good photograph of that. There's something that says ECU freezer. What does that depict?
The picture down here that's marked ECU freezer is a shot taken approximately what would be in this, on the map, it's marked Evidence Control Unit, room 36, partway between the lobby and what's marked as freezer, looking in the direction towards the freezer. It shows the door, a very large freezer area where we store our biological evidence.
Now, who can actually come into the evidence control unit?
The access through the door that goes from the ECU lobby into the Evidence Control Unit itself is limited to our property officers that actually work in that facility, can come and go through there. The administrative staff of the crime laboratory, in other words, the captain that we have, and then the 3 directors have access to that, plus a couple of our supervisors also have access into it, such as the narcotics supervisor who has to check in and out narcotics a lot for analysis. It simplifies life for everybody for him to be able to get access to that area.
What about the criminalists?
The criminalists do not have access through that door unless somebody from that does have access allows them in.
Okay. Now, if a criminalist has brought back wet stains from a crime scene in the plastic bags and then has dried them, they do that in the evidence processing room that we saw earlier with the roll-up door?
That's correct.
And after those are dried and the paperwork is filled out and they're ready to be booked, what do they do with them?
Well, once all the paperwork is done and they're packaged and all the seals are in place on the packages, they're taken from the evidence processing room to the lobby of the evidence control unit, at which point they're turned over to a property officer for storage. If it's a biological, it's stored in the freezer. If it's a liquid blood or urine sample, it would be stored in some refrigeration units we have. Everything else goes on just shelves that are room temperature storage.
So when the criminalist brings items into the evidence control unit window for the purposes of booking them, they are in a sealed condition at that time?
They're supposed to be, yes.
Are there any circumstances in which they can't be sealed?
Well, if the item is so large that it doesn't fit into an envelope or a box, example, again, being a shopping cart, I had to book the shopping cart myself about 4 or 5 months ago. Obviously, that is not going to be sealed into a big box. There's no reason to. So a tag is placed on it, and it is stored back in the evidence control unit.
But items such as the coin envelopes with the biological evidence in this case, those kinds of items, or the packages containing the reference files, those would be sealed before being booked.
Yes.
Now, And if they're freezers, if they go into the freezer, they're going into the freezer that's depicted here in photograph number 26?
That's correct.
All right. Now, what about the reference vials? Where do those go?
The reference blood vials, because you do not want to freeze liquid blood that are in the vials, we just want to refrigerate them. There are units that, for the bit, it's a motorized type of unit that holds bins that is refrigerated. The blood vial in its sealed envelope is placed into a bin, placed into this unit, and then can be rotated up and out of sight or out of the way if you need to look for another one.
Why don't we take a look at the photograph that says ECU Rotomats? It's photograph number 27. Is this part of the evidence control unit that we're looking at now?
Yes, it is. The picture that's marked ECU Rotomats is of these units that I was describing. They have the bins in them that can be rotated up and down, are located mostly all along the wall that's on the bottom of the map on the chart.
Why don't we take a look at the photograph that says ECU Rotomat refrigerator? It's 29. And is this one of the types of refrigerators into which the reference vials are placed?
Yes, it works in exactly the same way as the regular Rotomats, but it's refrigerated, so we can keep the items cool in there.
So then do these bins go all the way up to the ceiling and then in a circle, kind of on a conveyor belt type mechanism?
That's probably the best way to explain. There's shelves that can be rotated up and around, allowing us to get a large amount of storage in that area, and then being able to bring down a particular bin that you're interested in, remove your evidence item.
Now, when reference files are stored in the Rotomat refrigerator, are they stored in alphabetical order, or numerical order, or in some particular kind of order?
No.
So how does anyone ever find a reference file?
There's a evidence tracking system that we use in ECU and in the laboratory that allows us to use barcodes, and when for example, a reference blood sample inside of its sealed envelope, when it's first booked in by a criminalist or whoever, it's given a barcode. That package then is taken back to one of, and I think we have 3 that are refrigerated, placed into an open bin. The package is scanned, barcode is scanned, the location is scanned. They just put it wherever there's space for it, and then that information is loaded into the computer. So if you wanted to, at a later time, to find that blood sample, you would have to access the computer, enter in the DR number, find out what the item number is, and it would tell you in which bin it's located in which unit.
So if you tried to look for it manually, how difficult would that be?
It would be horrendous because we have probably a couple thousand at least blood samples stored in there. You'd have to go through every one of them and manually look at each one of them.
Now, with respect to the items that just have require shelf storage that don't require being placed in either the refrigerator or the freezer, where do those go?
But looking again at the diagram, we have shelf storage units that start down in the evidence control unit about where the word room is and run down the middle of this corridor past where it says evidence control. There's bins that are along the walls next to the freezer, along the walls next to what's marked flammable storage. And then there's also, if those are for the larger box items, there's also shelf storage in the Rotomats.
And does all of the evidence that LAPD has in its possession, is all of it placed into this room, the evidence control unit?
No.
What evidence is?
We want to only have evidence in the ECU that may someday be analyzed by the crime laboratory. The department receives very large quantities of evidence every day, and most of it we will never see within SID, within the laboratory. So we limit it to those things that will eventually be analyzed.
And are these security procedures that are set up in, well, let me ask you this first. In the evidence control unit, is there any evidence that's inherently valuable that's kept?
Well, we have narcotics in there.
And do you have anything else of inherent value?
We have long guns, handguns. I believe there is some money. I don't know where that is stored, but there are things that have value in and of themselves.
So are the security procedures that are in place designed to deal with the inherently valuable evidence, such as the narcotics and the firearms.
Yes.
And to your knowledge, has this facility ever had any problems with that kind of evidence being misplaced or stolen?
No, not to my knowledge.
Now, let's go to the serology lab and take a look at that. A photograph that says inside serology. Mr. Matheson, what does this photograph depict?
This is a photograph that's taken inside the serology unit, depicted on the map here. It says serology 25. The 25 is the room number. That particular photograph would have been taken probably about where the Z is in the zone 6 to 7, looking towards the right.
And towards the end of it is what appears to be a metal door. It's somewhat obscured towards the end of the room. It appears to be to the left of the clock.
Yes.
What is that?
That's a door that goes into a combination refrigerator and freezer within the serology unit. It's located, they're both located down the right side here of the unit itself. You'd enter through that metal door into the refrigerator and then walk through another door into a freezer.
What is the purpose of the freezer in that room?
Serology deals exclusively with body fluids, and they're biological, as mentioned earlier, that needs to be stored in such a condition so that they won't degrade. And the best way to do that is to keep it frozen. So while a case is in progress, it may be quite a while from beginning to end that evidence is within the laboratory, and we want to have freezer storage immediately accessible to the criminals that work in that unit.
Now, how does the evidence get from the evidence control unit into serology so that a criminalist can start working on it?
Well, at some point a request is made by a detective to do an analysis. They take the request, the criminalist receives a request, takes it over to the evidence control unit, and in the lobby hands this request to one of our property officers. The property officer looks in the computer to find out where the locations are for the evidence, retrieves it from the freezer, the refrigerator rotomats, or wherever else it happens to be located. It is then released to the criminalist, who has, like I mentioned, there's barcodes. The evidence packages are barcoded or scanned. The criminalist's barcode is scanned. Then they carry it back to the unit where they work. Use serology as an example. Back in the serology unit, then the criminalist is supposed to scan again, now that it's in the serology unit, scan the packages, scan their ID, so that the evidence tracking computer knows where it is at that moment.
And while you were working on the evidence in this case, where was it stored?
It was all stored, all the biological items that I worked on was stored in the serology freezer.
In the serology, the freezer in the serology lab.
That's correct.
Now, with respect to getting into the serology lab, what is required there in terms of access?
Well, the door into the serology lab, which is located in the top part of the room here that's marked serology 25, is a card access door, just like I described before. Anybody wanting to go through that door has to display their access card to the area where the antenna is in the wall. And if they have access to that room that time of day, that day of the week, you'll hear the door unlock and you can walk through it.
And who has access to serology?
Well, all the criminalists do during normal working hours. Any one of them can get into that area. The student worker that works for serology and trace can get into that area during normal working hours. And we have a photographer and some latent print experts that work in our laboratory. They also have access to it during normal working hours. Off watch and on weekends, the serology criminalists are the ones who have access to it. The other criminalists do not, along with management.
So if someone wants to work on evidence on the weekend, who can get into serology to work on evidence?
The criminalists that work that unit.
And what about access by police officers to serology? How does that work?
For a police officer to get into that unit, they would have to be escorted by somebody that has access to it.
Now let's take a look at the instrument lab just quickly. What is this part of the laboratory?
This photograph depicts an area of the instrument laboratory, which is room number 21, located actually on this diagram below serology. The photograph is being taken about where this blue diagram here is, looking towards the right.
Now, did you do any of your work in this case in the instrument lab?
No, I did not.
And let's take a quick look at the SID Parker Center amplification room. We discussed that briefly. Did you do any of your work in the SID Parker Center amplification room?
No, I did not.
And let's take a quick look at the Parker Center preparation room. And did you do any of your work in this room?
No, I did not.
Thank you. All right. In 1994, approximately how many cases did the serology laboratory process?
Or
I would have to refer to some notes I made of those statistics.
is this that same sheet you were referring to earlier, or different?
I'll have to check.
All right, Mr. Blazer, do you want to see that? Sure. Do you need it now, Mr. Blazer, or at the conclusion of the court day?
At the end of the day.
All right. Just remind me to do that.
That particular sheet doesn't have the data as far as that goes.
All right, Mr. Mathis, I want you to mark that with a Post-it just so that...
Sure.
Thank you.
Well, at the moment, I can't locate the page that I had that information on.
You can just give us an approximation.
Objection, no competition.
Overruled.
I would say conservatively, we did between 400 and 500 cases.
And how does that break down just roughly in terms of the type of cases? Are they rape cases or homicide cases?
They're split pretty closely, 50-50. We do a lot of both.
And what percentage of the homicide cases in Los Angeles, well, how many homicide cases in Los Angeles did the crime laboratory criminalists respond to for purposes of crime scene identification?
For
Do you
what
have
time?
that?
For what time
In
period?
94. Do you have that statistic?
I believe we did in the low 200s was the total number of cases that we responded to.
And what percentage of the total number of homicides do you respond to?
Oh, it would be approximately in the area of 10 to 20%.
And who is doing the crime scene investigation on the other 80 to 90%?
The detective.
Now, did you remove some stains or collect some stains from a console that was in the serology laboratory for this case?
Yes, I did.
And perhaps we could see People's 172 for identification. Just going to step down for a second, Mr. Madison.
All right, People's 172, which is a board that we previously described as the Bronco evidence. Mr. Goldberg.
Sir, direct your attention to the photograph that has the call-out lines 303, 304, and 305 on it. Do you recognize what's depicted there?
Yes, I do.
And what is that?
That is what's been described as a console that was removed from the Bronco.
And did you remove some stains from that?
Yes, I did.
Which stain numbers?
303, 304, and 305.
Does the call-out line depict the approximate location that those stains would be oriented on the console?
Yes, it does.
And when you saw the console, where was it?
Objection taken.
Overrules.
It was in the serology laboratory at the crime lab.
What date was this, when you
On-
removed the stains?
On September 1st, 1994.
Was anyone else,
I'm sorry. We object to this line of question. Case gone, change custody and regulatory ability.
All right, noted, overruled.
was anyone else present?
Yes.
Who was that?
I believe that I know that a Mr. Regal was present and Mark Taylor, and there were a number of other people, including members of the defense team that were present. I don't have the list in front of me right now.
And when you removed those items from the console, 303, 304, and 305, how did you do it? Using what technique?
The same technique that was demonstrated by Ms. Mazzola in the videotape and on the board, dampening a small cotton swatch with distilled water, applying it to the stain, allowing it to absorb onto the swatch, and then placing it in a plastic bag for later drying, and following that with a control.
Now, on this particular item, the console, did you see anything, any marks or indication that it had been swatched previously?
There were two of the three areas that I collected items off of that appeared to have already been sampled.
And which areas were those?
That would be the ones that are marked 303 and 304.
And do those correspond to any photographs that we have on this diagram, Bronco?
Yes, it does.
Which ones?
That would the area that I collected evidence as 303 is roughly the same area as marked in the upper right-hand photograph as item 30, and the area where I collected as 304 is in the same area as was marked as 31.
What evidence did you see that indicated previously that they had previously been swatched?
Well, you could see where a portion of the blood appeared to have been removed.
In terms of what? I mean, was there no blood there, or was it spread around? What did it look like?
Objection legal.
This is overruled. What did it look like?
Just looked like a portion had been removed. There's a lighter area that is consistent with how I've seen stains after I've removed blood from them.
Well, when you remove a stain from an object like this, is it totally gone as if it had been cleaned? Or is there something still left afterwards?
Normally, there's a little bit still left.
Okay, so there was a portion that you said was lighter, as if parts of that stain had been removed.
Yes.
And did you remove more portions of the stains in the areas that were in the vicinity of 31 and 30?
Yes, I did.
Now, what did you do with those items after you removed them?
Eventually, they were opened up, allowed to air dry, packaged in bindles and coin envelopes, and booked into our evidence control unit.
Or were they booked in a sealed condition?
Yes.
I wanted to show you People's 200 for identification. Sir, when criminalists go out to a crime scene, you said that they make a vehicle search, a crime scene identification checklist.
That's correct.
And when they go out to a vehicle search, is there a form that's used for that?
Yes.
And does the form indicate the date and time that they see certain items?
Yes, it's supposed to.
And have you seen let me show you People's 200 for identification.
Okay.
Is that a vehicle identification search pertaining to the Bronco?
Yes, it is.
And does it indicate that what date the console was removed from the Bronco?
Yes, it does.
Oh, what was that?
August 26, 1994.
Now, after it was removed from the Bronco and brought to SID, do you know where it was stored?
Yes, I do.
Where was it stored?
In the serology unit, we have a large layout table. It's in the middle of the room, and most of the items were sitting on that table.
Okay, thank you. You can resume the witness now. Actually, you don't have to move. Well, we'll probably be using that again in about 5 minutes. Sir, directing your attention to the date of October the 30th of 1994, did you take some cuttings from a item of evidence number 81?
I'm referring to a serology case summary sheet blood analysis that indicates that, yes, on October 30th, 94, I did remove some cuttings.
All right, Mr. Blazer, do you have that?
Not sure what you referred to.
All right, why don't you show that to him?
Maybe you can just give us the L number if it's on there.
It's L number 408.
All right, Mr. Blazer, you have that?
Yes.
All right, thank you.
Your Honor, I wanted to mark as next in order L number 409 as People's 201.
208. 208. Is this a single page, Mr. Goldberg?
Yes, it is, Your Honor. Sir, did the shirt bear the DR number? The packaging that the shirt was contained in bear the DR number in this case?
Yes, it did.
Can you tell us what the DR number is?
9408-17431.
I'm going to put 409 up on the Elmo in a second. You may want to look at it on your notes. So showing you the page that's entitled Serology Item Description Notes, People's 408, 208 in this case. Do you recognize that?
Yes, I do.
What is it?
It's a page, it's called Serology Item Description Notes. It is where I made notes in a sketch indicating the areas where I sampled item number 81, a shirt.
And on these, how are these serology item description notes used in the ordinary course of the crime lab's business?
Normally, they're used in conjunction with what's called a summary sheet. The summary sheet does that. It just summarizes the information that's found for a particular item. Attached to that would be a serology item description notes, which allows a more complete description of the item that you're working with.
And in this particular case, what does your sketch indicate?
Well, it shows a very rough rendition of a shirt with the letterings A through H, indicating areas where I made small cuttings of sample removal, and a circled area marked control where I removed a control sample.
And after you removed those items, cut those items, what did you do with them?
I placed them into individual bindles and then into a small manila coin envelope, placing them in the serology freezer.
Okay. Now, were those sealed?
No, I don't believe so.
Now, did you also review the documents in this case, including the serology item description notes, to determine when various items were mailed out and transmitted to outside laboratories?
Yes, I have.
All right. I'd like to direct your attention to the series of charts that we've labeled as People's 177 for identification. Mr. Matheson, showing you People's 177, the board contains items 6 through 24. Do you recognize that?
Yes, I do.
And did you have the opportunity to review this exhibit prior to your testimony today?
Yes.
Did you have the opportunity to check it against various items of various reports that are maintained in the ordinary course of the crime lab's business?
Yes, I did.
Now, you already mentioned the serology item description notes. Did you review serology item description notes in conjunction? Well, let me ask you this. What documents did you look at specifically in checking these boards?
I looked at a large quantity of documents, both what we described as serology item description notes, also some cover letters, transmittal letters, and analyzed evidence reports indicating where things had gone and when. Documents of that type that are all prepared during the course of of these samples being prepared and submitted to outside agencies.
Well, generally speaking, when you're going to send a sample to an outside agency, can you describe what kind of documentation you go through in doing that?
But when we need to send a evidence item out to another agency or a company to do work that we don't do ourselves, what is first done is a request to evaluate. We do it in the area of DNA analysis. A request to evaluate DNA evaluation on that item. And that is a form in and of itself. It gives the item numbers, describes the condition of the item, whether or not the person that's doing the evaluation thinks that there's sufficient evidence to send out or not. Ultimately, then, where it goes, which laboratory, the date that it went, how much is remaining of that item within our laboratory. There's also associated with that these item description notes, like I previously described, to give a more definitive explanation of what the evidence actually looked like, rather than, kind of a brief, just red stain or something on that line. Also prepared along with that is what's called an analyzed evidence report that just describes that these items were sent to such and such a laboratory on a certain date, which then is part of our permanent file, just like an analyzed evidence report, as if we'd done the work, letting the detective in the DA's office know, or whoever, that something had gone out for analysis on this laboratory. And there is also then a cover letter that is prepared to the laboratory that's being sent to, which describes the items that are being sent to them, giving them a very limited information about what the case is involved and who to contact in case they have any questions.
Do you also use something called serology case summary sheets for this?
These serology case summary sheets tend to be more towards analysis of the items. However, occasionally we will grab a form just to have something to write on, as far as it has lines.
And are all these standard forms that are used in the crime lab's business?
Yes.
And will the analyst then use these documents, such as the serology item description notes?
I'm going to object. Dr. Foundation, nothing as vague as the crime lab is.
Sustained. Phrase the question.
Are all of these documents ones that are used in the ordinary course of shipping items out when the crime lab does that?
Yes, they are.
Now, with respect to the usage, for example, of the serology item description notes, if the analyst is preparing the items to go out and packaging them, when does he fill out that document in relationship to the preparation and packaging of the items?
That is the document that's prepared while the evidence is actually sitting in front of him.
Now, does this exhibit, Peoples 177, essentially compile, or does it compile information from all of these various documents and just summarize them in one place?
Yes, it does.
And how voluminous were the documents that are represented here that are compiled in 177?
Well, this, along with a couple other charts, filled about a 2-inch binder.
Okay. Now, directing your attention to item number 6, just to start with an example, we don't have to go through each and every one of these. When you were verifying the information in item number 6, what did you look at?
The piece of information there of interest for myself was regarding the trip to DOJ. I'll start at the beginning. As far as the property report goes, these items were in fact collected on June 13th, and that was confirmed by a property report.
Okay, so the information in the left-hand column generally comes from a property report.
Yes, because that's the document we use when things are collected.
And did you take a look at the photograph in cell number 6 under collected LAPD to see whether you recognized the writing and the DR number?
Yes, I did.
And to verify that that was one of the items in this case?
Yes.
Now, what does Cellmark mean?
Cellmark is the name of a company. It's located on the East Coast that we use for our RFLP type DNA analysis.
Is that someone that you've used in a number of past cases?
Yes.
And what does DOJ mean?
DOJ stands for Department of Justice. In this particular case, it's the California Department of Justice Bureau of Forensic Sciences Lab in Berkeley, California.
So it's part of the state of California.
Yes.
And did you verify that, according to the records, an envelope containing swatches from number 6 was sent on the 12th of August?
Yes, I did.
Did you also look at the photograph?
Yes.
What did you look at the photograph for?
I wanted to confirm that one of those 8 coin envelopes that are depicted there was in fact the coin envelope that was used to transport item number 6.
And did it have the item number and the DR number?
Yes.
And is that typically how you would do it if you were sending less than the entire number of swatches? Would you put it in a different coin envelope to send it out?
Normally the process when the samples are being prepared to be sent to an outside laboratory, if we don't send all of the evidence, a portion or a cutting of it is taken from the original bindle and envelope, and a new bindle and envelope is prepared, which is then sent back to somewhere.
And that would be sent in a sealed condition?
That's correct.
Now, there's a little icon under 81294, and the legend says swatch with an ES, swatches. What does that icon represent?
That's to indicate in the case of item number 6, all that was sent was one of the stained swatches, no control.
And did you verify the correctness of that icon?
Yes.
So on this particular date, swatches containing presumably blood were sent, but the control was not sent.
That's correct.
And FBI, what is that?
FBI stands for the Federal Bureau of Investigation.
Now, in terms of this verification procedure that you testified to, did you look at the other items on this board and go through the same verification procedure of checking the documents and also the packages?
Yes, I did.
And was the information on this board correct?
Yes.
Now, with respect to item number 17, it says it's what appears to be a reference file. Can you take a closer look at that for a second?
That's correct.
Was that the reference file that you did some testing on?
Yes, it is.
And did you check the records to determine whether, according to the records, another item of evidence entitled OJ Simpson blood exemplar was created from that?
Yes, I did.
Objection.
Sustained.
Well-
Without foundation, jurisdiction disregard.
Did you have to check did you check a record to verify what says OJ Simpson blood exemplar?
Yes, I did.
What did you look at?
Some notes that was prepared by Mr. Yamauchi during the course of sampling the exemplars. It's our habit to try and get portions of the liquid blood when we receive it onto what are called swatch cards, so it can then dry out and be frozen rather than it's just stored refrigerated in the blood vial.
And does the analyst generate one of these records that you've described contemporaneously with doing that?
Yes.
And did you check that record to verify this entry?
Yes, I did.
Now, the little card that's represented there, the white thing, what's that?
Well, that's the exterior of one of their commercial swatching cards that we have. If you open that up, there's 4 black circles approximately an inch in diameter. Portions of the blood are pipetted or delivered to each of those 4 spots and allowed to dry.
Okay, now, with respect to item number 13, for example, did you take a look at the picture of the exterior packaging to see whether the item number and the DR number was represented? hard for me to see.
Yes, I did.
And did you also check the records to see that that was sent out on September 26, 94?
Yes.
So with respect to item 23, for example, that would have been sent out on September the 14th of 94?
That's correct.
But with respect to that item, did you verify that both swatches and a control was sent?
Per the records, yes.
Okay, thank you. See that will next forward.
I have an objection to another board. Could we briefly approach while they're finding it?
All right, juror number one, is that too extreme for you to see? Well, we're sort of defeating our purpose here. Let's put it back at a straight 90 degree. And we'll proceed at that point. We may have to move some of those exhibits from out back there so we get a little more depth here. All right, Mr. Goldberg.
I only have about 2 minutes of questions on this one, so they might want to stay there. Now, direct your attention to the board that has 25 through 44 on it. Did you go through the same verification procedure on this board that you previously discussed?
Yes, I did.
Okay, and was the information contained on that board true and correct?
Yes, it was.
I see Mr. Fairtlow was just.
All right, Mr. Goldberg, are you ready to proceed to the next chart?
Yes.
All right. All right, Mr. Rather than move all of those, let's, right now, we'll do that later. Let's move on to the next chart.
Now, this is the one that has items 45 through 57. Mr. Matheson, on this particular chart, did you notice something in reviewing it that you wanted changed?
Yes,
Do we have the exhibit number?
Well, these are all 177.
177, this is items, we have it marked by items, item numbers.
This may be, we may have put a letter, maybe C,
All right,
but it has 45 through 57.
noted. Thank you. Proceed.
Thank you.
yes, I did.
And which was that?
And that was in the case of item number 51, under 2 DOJ 92694, the icons for swatch and control had been omitted.
We have some icons here, maybe with the court's permission, we could just put them on. That's the 92694.
That's correct.
And which item was this?
Item number 51.
51. All right.
So sustain and control icon.
That's correct.
While he's doing that, maybe I, well, just wait. Other than that, Mr. Matheson, did this board correctly state the information that was contained in the business records that you previously described?
Yes, it did.
All right, thanks. Let's go on to D.
And Mr. Goldberg, these are which items?
177, I believe this should be D. And this is item 59 through 82. Now, with respect to item number 59, Mr. Matheson, did you also take a look at some documents, as you previously testified when we were asking you about item 17, in order to verify the creation of the Fitzco card under Nicole Simpson blood exemplar? If you understood that question.
Yes, I did.
All right. Did you do that?
Yes.
And when did it indicate that the swatches were made from item number 59?
On June 5th.
Objection, no foundation.
Sustain.
What documents did you look at?
It was the same document mentioned before, prepared by Mr. Yamauchi, describing the swatching of the items.
And that's prepared in the same way that you previously testified when I was asking you about 17?
That's correct.
And when did that document indicate that the swatches were prepared from 59?
Objection, improper foundation.
Sustain.
Well, is this done in the ordinary course of business?
Yes.
And is the document that you looked at prepared contemporaneously with the swatching?
Yes.
Okay. Is this a standard form that's used in the lab?
We don't have a standard form to just to describe the production of these swatches. He used one of the ones I mentioned earlier as a note page.
Okay, but are those items that you use, that analysts use to describe what they're doing and when they're creating a particular piece of evidence?
Yes.
And when did that indicate that the Nicole Simpson blood exemplar was created?
Objection, foundation.
Sustained.
May we approach?
No, proceed.
Because the council hasn't specified what element of foundation he's saying is missing.
Doesn't have to. It's missing. Proceed.
Okay. You looked at a document. Is that correct?
Yes.
Okay. And that document was prepared by who?
Mr. Yamauchi?
And this is a document that's prepared at or near the time that the swatch is created?
Objection, foundation.
Overruled.
That's correct.
And this is a document that is used by serologists when they are preparing swatches?
Yes.
And did you check that document against the item that's referenced as the Nicole Simpson blood exemplar?
Yes, I did.
And did it reflect, does this accurately reflect the information on that document?
Objection, no foundation calls for hearsay.
Overruled.
Yes, it does.
All right, and when did it indicate that that swatch was created?
Objection, no foundation.
Sustained. We're missing item D, counsel.
What?
We're missing item D.
Well, is this done in a manner that's trustworthy?
Objection.
Sustained. Calls for a conclusion. Has to describe the manner in which it's prepared.
I think he just did that.
That indicates its trustworthiness.
Mr. Matheson, when does the analyst actually write down the information?
Objection, irrelevant.
Overruled.
As they're performing the work, they are preparing note pages describing the actions that were taken.
And what does he describe? What do they describe?
Objection, calls for hearsay.
Overruled.
That swatches were prepared of particular item on a particular date.
Okay, and when was that item prepared according to this document?
Objection.
Overruled at this point.
June 15th, 1994.
Okay, now did you go through the same process with respect to the Ronald Goldman blood exemplar?
Yes, I did.
And is the information contained there accurate?
Objection, no foundation.
Sustained.
You want to go through this all over again?
There's an objection, counsel. It's your burden. Proceed.
Okay.
What document?
What type of document did you look at in order to verify the information under Ronald Goldman blood exemplar?
I believe it was a item description note.
Was it the same type that you just testified to when you were talking about 59?
I believe it was the exact same document.
Okay. And what did that document indicate in terms of when the swatch entitled Ronald Goldman blood exemplar was created?
Objection, hearsay.
Overruled.
That it was prepared on June 15th, 1994.
Okay. And did the swatch come from the vial number 60,
Objection, no foundation.
Sustained.
according to the document?
Objection, based on hearsay.
Overruled.
Foundation.
Overruled.
According to the document, the swatch was made from the whole blood vial.
And is that the same answer that you give with respect to the Nicole Simpson blood exemplar?
Yes.
Does this board accurately indicate when items from the swatches were mailed out and to whom?
Yes, it does.
Now, with respect to item number 81, did you look at the photograph in the cell under collected LAPD to determine whether you could recognize the packaging?
Yes, I did.
And is that the shirt from which you took certain cuttings that you testified to earlier this afternoon?
Yes, that's correct.
Where are those indicated on this board?
The cuttings that I made are indicated in the next cell down opposite 81A through H cuttings.
And where it says October 30th, 94, Greg Matheson.
That's correct.
So that's when you took cuttings from item 81.
Yes.
And does the cell under DOJ that says 11395 indicate when that was mailed out?
Yes, it does.
Now, with respect to item number 82, what is that?
When samples are collected from the coroner's office, they prepare both a liquid sample and a swatch of blood. That is the outside packaging or the envelope that contains the swatch that was prepared at the coroner's office, marked as Nicole Brown's reference.
So that is not done, that particular swatch is not done by SID, it's done by the coroner's people.
That's correct.
And does the cell under DOJ under 9794 indicate when that was sent out?
Yes.
Okay, thank you. Let's take a look at the next board. This is the final. So on this board, did you also find something that you wanted to change?
Yes, I did.
What was that?
That in this cell next to where it says 293 fibers in control, it has a date of 8/26/94, and then Matheson as to when that was collected. The actual date on that was 9/1/94.
And was this an item that also came from some object in the Bronco?
That was collected from the Bronco, that's correct. The item was not in the Bronco when I did my collection.
What was it that you took it from?
I believe that was from a section of the floorboard or floor carpeting.
Okay. That had been collected by someone else.
The carpeting had, that's correct.
Right. And what did you do? What technique did you use to collect 293?
Just cut portions of the fibers away from the carpeting, placing them in a bindle, closing the bindle up, and then making a control cutting, and placing that in another bindle and putting it in a coin envelope.
So this was not the cloth swatch technique?
That's correct.
And the control was a cloth swatch or just another piece of carpet?
It would be more cuttings of fibers.
So where did you cut from in order to get the control?
Near to the stain, but in an area that did not appear to be stained.
Right. Now, with respect to item number 84 and 85, let's start from 80 with 84. Do you recognize what's depicted in that item?
Yes, I do.
And what is that?
Item number 84 is a LA County Coroner's envelope used to store collected fingernail scrapings or fingernail clippings and or scrapings.
Did you do some testing on 84?
Yes, I did.
So this was something that was not collected by SID people?
That's correct.
And with respect to the other items on this chart, and this chart it contains 84 through 305 for the record, did you verify the correctness of the information contained on this chart?
Yes, I did.
And perhaps with the court's permission later on, we could change the 8/26 date to 9/1.
Yes.
Thank you. Next, I'd like to mark another exhibit that's entitled Additional LAPD Disposition, Evidence Disposition Board as 209.
Hold on. Yes, please. Tell you what, ladies and gentlemen, I need to. Why don't you turn that around, Mr. Fritlow? All right. All right, ladies and gentlemen, I'm going to need to talk to council about this next exhibit. Probably take us more than 5 or 10 minutes, so I'm going to call it quits as far as you're concerned for the day. I have a few other matters I need to talk to the lawyers about. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. And we'll see you tomorrow morning at 9 o'clock. All right, as far as the jury is concerned, we'll stand in recess. And Mr. Matheson, you may step down. You're ordered to return 8:45 tomorrow morning. And Mr. Goldberg, how many of these do we have? This is it.
Yeah, these are what I call the round trip items.
The round trip.
They're items that came back and then went out again. So they had to be put on a separate board.
All right, are there any other items similar to this that we need to talk about?
You mean boards? No.
There's one on the board.
I didn't know council had any objection to this because I think we've had it down here for a while, and I would have liked. I thought we had an agreement that we were supposed to know.
But this
so
raises that issue that we would
I
like to
understand
discuss.
what the issue is, but
Yeah.
I just still wish that we sometimes come armed with patches if we think that there's a problem.
Which is why at this point, the point of my question to you, Mr. Goldberg, are there any other exhibits that you have not previously shown to the court and defense counsel that you intend on using tomorrow?
I don't think so, because I think I've shown all that to the check. They have everything. I'm going to also use the analyzed evidence report that's L371 that was used in Mr. Cochran's that's on laser and has certain pullouts on it. It's very similar to what he used in his opening statement. And
All right, Mr. Blazer, you're familiar with that document?
I don't know that I've seen that. Has it been used before?
No, except in the opening statement.
I would just like a chance to look at that tomorrow.
And then I also have,
Well, Mr. Fairlow, do you have the ability to pull that up right now?
Yes, Your Honor.
and then I also have an electrophysis worksheet that they have, except it's also on laser and it has a pullout on it.
All right, let's see them both.
Just have to switch cases.
Do you recall from my revised council conduct order, this is what we're going to do every day at 4:30, look at new exhibits for the next day?
Your Honor, it's my understanding that that order doesn't apply to impeachment materials.
That's correct.
Okay.
Any affirmative stuff that you intend on presenting, I want to see it at 4:30 the day before, so we don't have to stop and start. affirmative evidence as opposed to impeachment evidence?
Well,
This is the.
I need to clarify that in a minute.
Well, let's start with what the prosecution has.
There are 3 sections to it. This is section A.
All right,
This is section B.
all right.
This is section C.
Okay. And Mr. Blazer, you now recollect having seen these reports?
Oh, yes, I have no objection to this.
All right.
I hadn't seen it in the laser form.
Next item.
It's not on laser.
I have no objection to this.
All right, what is that for the record?
That's electrophoresis worksheet, and it has a B and a question mark under item 84A and 84B.
All right, is there an L number on that?
It's L388. Then I have L383. I've shown all of these exhibits this morning, so there
All
is
right,
nothing new.
And Mr. Blazer, there are no objections to those other items?
No.
All right. All right, let's talk about evidence, additional LAPD evidence disposition summary chart equals 209. I take it, Mr. Blazer, your objection is to column 2?
Correct.
What case law are you aware of that precludes the prosecution from, in their presentation regarding the integrity of the evidence, to not put this on? What precludes them from doing that?
Well, I think we briefed this before in the motion on the stipulation. I don't have that at hand, but presumably the
I'm just asking, do you have any other additional?
nothing additional, no.
All right.
I'm assuming that what it's being offered for is to just establish where the items were during a certain period of time. And you don't need to go into what happened to the items, speculate about what might have happened to the items, about who had them. We're willing to stipulate to that. We're not challenging it. I know we can't make them stipulate to it, but we are not challenging it. And it seems inappropriate that they should be able to go far beyond what limited probative value this information has.
Well, if the chain of custody were stipulated to, which would be the normal way that things are done in a case such
Well,
as
Mr.
this.
Goldberg,
We
there's
will.
nothing normal here.
I know that, but even if it was partially stipulated to.
We will.
But-
We'll stipulate it to it
but-
for any time.
Hold on.
Well, if they're going to stipulate that there's, that the only portion of the chain of custody that they're contesting is between the scene and the evidence processing room, which they've already contested through Mr. Fung, and then that's it, then a lot of this becomes irrelevant. But that's apparently not what they're doing. They're I think, contesting almost every portion of the scene, even after the things were in the laboratory, between the time the things were at the laboratory and mailed out. They wouldn't even stipulate to laying the foundation on these boards.
All right. My inclination, though, is to say that the prosecution is entitled to show that for a period of time, these items, as designated here, were in the possession of representatives of the defense, and that's the end of it.
That's not,
And
we're
that
not going
some
to
of
say
it,
that.
and I don't recollect particularly how much was used of any particular swatch.
Well, the problem with that is that opens the whole area up as to what we did with them, and we'll have to go into the fact that we weren't allowed to do anything to them, that we weren't allowed to perform any testing, that it was just an examination. And it seems to me that we're going to get off on a real long trail here that has very little impact on what limited probative value this information has when we're not contesting it.
So how do you propose to do this?
Yes, Your Honor, if the information is going to come in that we had these items, then it needs to also come in that we were not allowed to do anything to them other than examine them, that we were not allowed to take samples for testing. We were not permitted to do anything other than physically look at them.
All right, Mr. Goldberg, do you have anything else to add that is beyond the points and authorities submitted regarding the proposed stipulation?
No, but I did want to clarify one thing for the record. The courts said that you were inclined to allow this as long as we didn't have any evidence as to what happened. And generally speaking, I think that that's exactly what I intended to do with every single item, with the possible exception of item number 6, because item number 6 went out to Albany, did not have any hair in the bindle. But when it came back, it was photographed, and it does. So however it happened and whoever was responsible, that bindle became accidentally contaminated, which is kind of interesting because it was still tested and I believe still came out as clean. It doesn't have any biological evidence on it. Obviously, no one would intentionally contaminate a piece of evidence, but it is sort of interesting, and it would probably be very interesting to these jurors that it did become contaminated, as the defense has used that word, and still there was absolutely no impact on the evidence that was tested. So I think that it is relevant to bring that out.
Actually, I'm sorry. That's not accurate. That hair was there when we got it, and we have fully documented that.
All right, well, we'll see. I'm sure it'll come out in front of the jury in some form. All right, I want counsel here, Mr. Goldberg, Mr. Blazier. I want you gentlemen here at 8:30, and we'll continue the discussion. As I mentioned to you, I'm not comfortable with the state of my research on this particular issue, so I want to have a little more time to look into this. I think we're done with the argument at this point.
I just wanted to point something else about the chart. But it's not a further argument. But I just did want to point out that in all these items, the only reason why we're putting these items went to the defense, even though there were many more, was because they went to the defense between the time that we received them back and the time that we mailed them out again. I also wanted, for the record, to say that we'd like to use some photographs of the socks, which have not been previously marked, which counsel has. And I am going to use this EAP phenotype block diagram, which they've seen probably about a month ago now, but they may have forgotten that they saw it, so I wanted to put that on the record.
All right.
I don't have any problem with it.
All right, counsel, what we're going to do is find some other way to store all of these because we need a little more working room there. Also, counsel have been inviting their witnesses to take the witness stand prior to the court coming out. It's for the court to invite witnesses to take the witness stand. All right.
Sorry, Your Honor.
Oh,
The
just-
courts have different practices.
Yeah. Yeah.
Your Honor, can I have your board back? Just with time out.
That's
Your
why
Honor,
that's why we're here at 4:30.
Right. There is just, at this point in time, we still have not had any introduction of the actual results of the either conventional serological or DNA tests.
I suppose that's tomorrow.
I know that. So what I just wanted to bring to the court's attention right now to consider is as an additional ground for, at this point, precluding that kind of testimony tomorrow morning from Mr. Matheson, is that it's not just simply a question of foundation testimony from the nurse. The blood itself hasn't been introduced into evidence. And frankly, I've looked at the California law, and I don't know of any cases, for instance, which say that it's okay to have a laboratory technician testify that a certain substance contained cocaine or heroin without first introducing the drugs that have been seized. And I have no case law in California that sustains the introduction of test results without the blood coming into evidence. And we would oppose, on an additional ground, the introduction of any results until the blood itself is introduced.
Noted. Thank you. All right, see you gentlemen tomorrow morning. Mr. Blazier, one more thing.
One more thing, yes. I
Well,
don't
you
want to.
yielded the floor to Mr. Neufeld, so
Well-
I assumed that you were done for the day.
No, I don't want to run afoul of the court's order. I have some slides that I prepared to illustrate points I intend to make with Mr. Matheson on cross-examination. That was my understanding because that was impeachment material that I don't need to provide that to them now. But I want to make sure that I'm clear on that.
Yeah, now.
They have a very
Okay.
loose definition of impeachment material, and I know we've gone over this over and over again.
Not any new original evidence or anything like that, but just.
No, what I will require you to do, however, prior to the session that you're going to use it, advise the court and counsel that you've got it, just in case there are any objections to it, without discussing it with the witness that's involved.
That's fine. I'll do it after he's done with his drawing.
All right.
Also, on any of these items, as the court knows, we have very voluminous photographs and so on. I don't bring everything, but I bring this cart down every day. That's only a very small fraction of everything.
Also, you're going to have the notebooks piled up there on the second tier below, because sometimes it obscures views and things of people. So keep it below.
I have tried to do that.
Keep it below the level of the rail.
I may have put that notebook there just a few months ago. I'm not sure.
Okay. But I'm sure some of your minions upstairs, if they hear that we're using those other photos, will rush them down here.
Yeah, but it's just that it would be some delay, 10 to 15 minutes, depending on how crowded the elevators were at that time.
Well, be prepared. All right. Anything else? I will stand in recess 8:30 tomorrow morning, council. Thank you.